put the air on, but it didn't come on.
I brought my sweater because yesterday was cold.
Yesterday it was cold, so I tried not putting it as down as far. I only went down like 1 or something. Hello.
What are you doing?
Put an air on.
Alright.
Totally agree.
I know a guy who does that. He doesn't like people touching it.
Oh, yeah.
Oh, we're switching it up today, huh?
No.
No?
Did you see the education?
I can't. I can't. I already read that, and then my best friend sent it to me. And I was like, I want to be supportive of like a woman who wants to go to law school, but I am struggling with the idea that it's like, it literally made me think of the line from Legally Blonde where it was like, she just woke up that morning and decided to go to law school. Like,
It's hard.
yeah, like, but I just feel like she's being so cavalier about it. Like, she's obviously doing like a law of the study kind of option. Yeah, but I'm just like, I like that it's, well, the reading's really difficult, but you know, I get all these concepts in 2 seconds. I'm like, oh really? Rule against perpetuities, go. Like, it was just so off-putting.
My favorite was like, I could be criminal in my sleep.
Okay? Have at it. She gets one person released, and now she's the
A Kardashian said that?
Kim. Oh yeah, she's already a year in. She's gonna take the bar in 2022.
It's taking big bar this year.
Is she?
Mm-hmm. It's taking big bar. I think they did it in June.
You know, I hope she passes. Good for her. She's got a good platform. She can get this information out there.
So is that another one they're gonna pay for her to pass the big bar?
Right? Yeah, that was an interesting one to read for sure.
I just feel like it wasn't his fault. That's good.
But it's not fair, Your Honor. Okay. She should specialize in revenge pornography. That's terrible to say, but it's like she would have a frame of reference. Except I think they said she released it or her mom released it, right? Who's excited about recording statutes? Who thought the language was a little old and difficult to understand? Right? What's that? Oh, okay, Kim. Just kidding.
It was long, but I got it in 2 seconds.
I just thought it was a little cavalier to like say that. Like, cool, if you want to go do that and put in the work, great.
I feel like she should have passed the water before she had to.
I think that would have been a wise idea.
Did you hear Kim Kardashian say baby bar?
That's
No, serious.
Have you been sitting in the room?
So we've been talking about.
No, we were literally.
Oh my god!
I was like, is this a joke?
She just walked in.
Oh, okay, because I had my head down and I was like, I'm so confused right now.
So we were talking about
Yeah.
That's amazing. I literally time lapsed for a second and I was like, did we just say this? Oh, that's amazing. Yes, we did.
So
And
is she gonna be the part of it?
I think that's the only spot.
Wait, so she's
LA,
taking it
right?
in June?
There's one in San Francisco and. Is she
Okay,
lives in
yeah.
Calabasas?
Yeah, that's,
She'll go to
So baby bar, yeah, but for the bar exam, she'll probably go to Pasadena. Oh, they have there too?
I think she's doing it in San Francisco. I think the trade should be in San Francisco. So she might be into that big location.
I want to understand how many hours you're putting in if it's in San Francisco. I guess a lot of it is independent study. She's probably doing like a chambers, like they used to call it like a law office studies kind of. There are a few things more unpleasant about paperwork than having to correct something on 8 million different pages in writing because everything's already been signed. You have to correct an address. Ugh. With like the world's longest address. Mm-hmm. Should have told you that one. Everybody deserves an opportunity.
That's my job.
Uh-huh. Good. Uh-huh. If it makes you feel any better, recordings will be easier than rule against perpetuity. Silver lining. What page? All right. So, what I can say generally about recording is you're usually going to have multiple parties. You need to keep them all straight, so sometimes writing them out can be helpful, or just, making a little key of who the parties are can be very helpful to keep track of things, because ultimately you have to have almost at least 3 people, right, to deal in recordings if you're going to get a good recording case, or more. So we do also get into the issue of notice again. How many types of notice do we have? 3. What are they?
Actual record and
Error, yes. Actual, inquiry, and record, right? So I want you guys to be mindful of that. That becomes very significant here because we start talking about bona fide purchasers. And one of the elements there is that they take without notice. So you must address the issue of notice, okay? So I'll get into more solid rules of recording after we get into some of the cases and start seeing some examples. So let's go ahead and start on page 1137 with Mountain State Telephone. Who'd like to take that case? Okay.
So here, John Kelton and Son were contractors, and they entered onto the property with heavy digging equipment. and they damaged an underground cable belonging to Mountain States Telephone and Telegraph. The landowners of the property were held to be negligent because they had actual knowledge of the cable, and the court said that they failed to take proper precautions. Here, the plaintiff, which is the Telegraph and Telephone Company, is seeking damages for injuries inflicted by the defendant to their underground telephone cable. Procedurally, the lower court ruled in favor of the defendants, and now the plaintiff appeals. So did John Kelton and Son have a duty to search the title of the property before working on it? The rule I found is on page 1138, and it says, it is sometimes said that the record of a deed is constructive notice to all the world. That it is evident is too broad and unqualified an enunciation of the doctrine. It is constructive notice only to those who are bound to search for it. So here the court said that Kelton and Son had no actual notice of the buried cable, and it was not apparent from visible inspection made by them on the premises prior to beginning their work on that land. So the court disagreed with the plaintiff in the argument that the defendant was required to search the record and that they should have noticed. So they said that they did not have a duty to search the title before working on it, and they upheld the lower court's decision.
The people that were doing the work, did they own the property?
No, they were contractors,
So whose responsibility was to look at?
the landowners.
Right. Is it reasonable that as a contractor, you should have to go and pull title and go look at the record to see if somebody put a cable underneath something there?
No.
I don't think so. What was their argument?
Whose argument?
The contractor.
Well, they said that it was putting a burden on them, and they did a visual inspection and they didn't find anything.
What kind of burden?
Is it unnecessary?
I mean, I don't remember the specific word. I mean, it's effectively, you're just saying it's an unnecessary, undue, or burdensome, unduly burdensome on them to have to do that because they're not the interest holder in the land, right?
Yeah.
I mean, certainly if you were doing some other kind of job that was more invasive, then that would be one thing, but I don't think they could have known that it happened to run under there, right? So what did they ultimately say?
They said that the contractors don't have, that duty to search for the title. It was the landowner who was negligent.
Which landowner? The owner of the property at that time?
Yes,
Okay, because they were suing the contractor.
yes, exactly.
They basically said, you should know what's going on with your own land, and we're just coming on property. Now, what's the contra argument there?
That there's the telephone company is still suffer damages, they're entitled to damages.
No, I mean, what's the contra argument there of it being the responsibility of the contractor?
Oh, that it's not their duty to look for it because they did a visual inspection, so they did their due diligence and they're being brought onto the property, so.
No, my question is, what would be the argument against the contractor?
That if they're.
What is the argument of the homeowner?
That if he would have gone to search the record, he would have known that it was recorded that there was a line underground.
I don't think I'm articulating my question well, it's my fault. Why is it that they believe it was their responsibility to go check the record?
Is it?
I mean, if I'm the homeowner, I'm thinking I'm contracting somebody that does this as a profession. It's a licensed contractor, I presume, right? It's not unlicensed. Then you got no argument. This is a licensed contractor. I'm hiring somebody for their expertise. They should know that if they're going to be excavating on my land, they should know what's underneath it and have some means of determining whether or not they're going to hit some pipe, rebar, whatever it is that might be under my property, right? So I'm kind of paying for that expertise. Otherwise, I can just go dig up the hole myself, no? So that's kind of their argument. Look, I am hiring somebody that's a professional here. I didn't hire the neighbor kid to go dig a hole for me and he hit something. So that seems to be the best argument for them is they should know how to do their job properly. And if they're going to excavate, they should have some means of determining what may or may not be under the property. Now, chances are, if you're going to require that and require them to go do record and title searches, you're going to be charged a lot more money, right? Because it's going to be much more labor intensive for them to have to go and do that kind of legwork just so they can start digging a hole, right?
Mhm.
And at the end of the day, you should know what's going on with your own property. You should be able to advise somebody that's coming onto your property, that you are inviting onto your property to do this work, what it is that you have on property, right? It would be one thing if they said, look, we appear to have a leak under the slab, right? So we've got a slab leak, we don't know where, if you could just, then we want you to try and determine where it is. That would have been different. But this is, we are unaware of the structure and underground of our property and basically made no efforts to determine if you were going to hit anything, and neither did you, but we're the ones that have an interest in the property. So I think that they're still the more culpable of the two, right? I don't think they should have just gotten away scot-free on it though. Sorry, got a little worked up on that one. That was worked up for Wednesday. Sorry, that's not Hayashi.
No, nowhere near the red hotness on that one.
It's a pop-up.
Still,
100
yes,
grades.
please have a seat.
Just kidding. Well,
Well,
fine
it's-
grade.
I, you know, it's funny because, yeah, that sounds good. I just want to throw something in though about this case because I've actually handled cases like this, not this exact situation, but very, very close in certain instances. And see, to me, this case was decided correctly, and I'll tell you why I think it was. Let's say that you're a contractor, right? You know, let's say you're a homeowner, and you hire a contractor to do this work, right? And you know what they're going to do, right? And here come the contractors, right? And here they start digging, right? And they hit a pipe or something, which happens more than you think, right? And they break the pipe. And then someone has to pay for it, right? Most of the time, the homeowner loses. Why? They almost always lose. Why?
Because it's on their land.
And what is the contractor's actual argument in the courts that they always say, and because of that, they always win. Almost always win. If they were to come to me, I would have told them exactly what to say.
The landowner should warn them.
You knew it was there. Why didn't you tell me? That's a pretty damn good argument when you're in front of the judge. I have news for you. Because then you look at the owner and you say, you're a lawyer, you say you had actual notice. Why didn't you tell them? Because it's not likely, take it from me, I can't say I don't know of any contractors look or not ever. I don't think they're gonna look. Why don't they look? Because they expect you to tell them because you already know about it. You see how that kind of works? It's just actually in a funny way, just logical. And so when you sit there and what would you say to the homeowner if you were a judge and they were sitting in front of you? And all of a sudden I said, well, why didn't the homeowner tell my client it was there? They knew it was there.
Why isn't there something in a contract, like that, in every contractor's contract saying that they have a duty to ask the homeowner, where are the underground pipes?
Well, they might say that, but they can say that, but I would argue that of the two parties, who has the duty to disclose? The one that has actual knowledge and knows it's there, or the one that you can pretty much assume that it's not marked? Now, if it's marked, that's another thing, right? You see these little things or something. But this was an unmarked, pipe. And there's lots and lots of pipes under houses. I got news for you. A whole bunch of them. You'd be surprised. And really, we don't put it upon the other sort of public policy argument, which you may or may not make in a court actually, but yeah, you might maybe, but is that how many of you have actually ever looked up title? None of you at all? Well, did you ever buy a house? Well, then you had it done for you probably. But if you've ever actually looked up title, why would you? Because you're buying the land.
Yeah.
You don't look it up. I don't know if anyone has ever looked at title in their lives for anything other than buying the land. So therefore, isn't it better in public policy to just keep it that way and just assume that really, yeah, it is notice to the world, but it's the world of people buying land, because we all know that's what it's there for. It's not really there to hold, contractors liable for these things because they could have looked it up. Especially under the circumstances when you could have told them. You're seeing it. I mean, I want you to think about this. This homeowner is sitting there watching them digging. And they know the pipe is there. I think about it. Does that really make any sense at all? Wouldn't you, if you were the homeowner, walk over and just say, I think there's a pipe there? Not even I think there's a pipe there. I know there's a pipe there. Would you please not, dig into a pipe? Particularly a gas pipe, because you might blow us up. So you see how ridiculous that is that they did this? I mean, that can be very dangerous on top of everything else. So there's also even an element of, in this case it wasn't, but can you imagine that someone would be coming into your yard digging near a gas pipe and you don't tell them? How negligent is that? And then you blow up half the neighborhood, right? It's his fault. Really? Who do you think they're going to sue in that situation? The homeowner's going to get pummeled, right? Why didn't you tell him? You knew it was there. Plus, you hired him. Oh my gosh, I got that case. I'll take that one any day of the week. That's not quite a slam dunk, but pretty close.
You hired him, you directed him where to do this.
And you blew up our neighborhood, you fool. Don't think it doesn't happen. Things like that do happen from time to time. So, not too often, thank heavens. Usually, for some reason, it's water heaters that blow up. Don't ask me why. But that happens a lot. True. Anyways, so does everybody get this case? Right? So we have a situation where they're explaining to you actual notice, inquiry notice, and then constructive notice. So you have kind of all three going through this case. That's kind of why they lead with it. Because were they on inquiry notice? Should they just look around every time? And the answer is they looked around. They did do a visual inspection, so that's inquiry notice. Is that good enough? Sure. Particularly under the circumstances where the homeowner knows the pipe's there. So why would I go any further? Doesn't make much sense. So we see all three, and then constructive is just putting it on, file, just recording it. But in this case, we have kind of a truncated rule because, notice is to the whole world, but from this case, we know the whole world only really consists of people who buy land, right? That's so? Okay, so that's why they put this case first, because it actually does touch on all the different types of inquiry and kind of the effect that they have. So even though it seems like it's kind of a tricky cat case, but actually pretty good case to figure it out. So if you figure this one out, you probably are halfway there to actually understanding notice, believe it or not. So, yes, everyone good? Okay, good job, off and running. Okay, can you do one more? It's not feeling for sure today. Ooh, 7 versus 10. That's an interesting case.
I'll do this. Okay, so this is a 1887 case. And on March 1st, 1878, the property belonged to a Francis French, even though he had not paid off the property yet. So at that time, Francis French formed the intention of giving his land at his death to his brother, Dudley French, unless Francis should sell it during his lifetime. So on March 1st, 1878, Francis wrote a letter to his brother Dudley stating that in case I should drop off, you can take possession of the land and do with it as you please. When I have paid the land out, if not sold, I will make a deed to you, enclose it in an envelope, direct it to you, and to be mailed in the event of death, which would make it sure to you without expense or trouble. So a year and a half later, on February 18th, 1879, Francis signed a warranty deed for the property to Dudley French. And on April 4th, 1879, acknowledged the deed before an S. Michaels. He was the Justice of the Peace in the county. So the deed contained the words signed, sealed, and delivered in the presence of S. Michaels. But the deed was never delivered. So on August 2nd, 1879, Francis died. So during this time, while Francis was he was a single man and he didn't have any wife or children or anything like, or even a mother or father, they were all had passed, but he did have several brothers, including there was a plaintiff, Luther French and Dudley French. But it doesn't appear that any person except the Justice of the Peace, Michaels, and Francis that ever saw this deed. And nobody had the slightest knowledge of this until after French had died of this deed. And
Where was it found?
huh?
Where was this deed found?
It was found in a cigar box in an envelope it was in the residence of French. And it was, it sounds like it was a person living there that found this, that after he had passed.
Well, let me just do the whole thing, just so everyone, hopefully you're all clear on this. Okay, so until about a half an hour before he died, that's when it was found, half an hour before he died. When it was found by William Welsh, enclosed in an envelope with a letter in a cigar box in a drawer of a table in a house occupied as a residence by French. Did everyone get that from this case? They just sort of stumbled onto this letter because people were looking through his house before he died, seeing what they could steal, probably. Believe it or not, would be my guess. Ooh, what's he got here? Ooh, what's this letter? Nice, huh? I've heard worse, believe it or not. I know that sounds weird, but this is pretty typical, believe it or not. And it happens. This is an 1887 case, but this still happens all the time. Even today, find these really weird letters all over the place. 2 and 3 different wills. I've heard of that. It's not unusual. Anyways, carry on, please.
So
Carry on.
What kind of deed was this?
a warranty deed.
What kind?
It was a, I think it was a,
I know they just refer to it as a warranty deed, but
warranty deed, but was it a quick claim deed?
no. Warranty deed would only fall into a general warranty or special statutory warranty deed, or statutory special warranty deed.
Oh, then this was a
Because it makes a difference for what obligation
then it would have to be
the
a
predecessor
general.
has, right?
A general, wouldn't it?
Go through the facts a little bit more.
Okay, so I know I had to actually draw a diagram on this one because there are so many people involved in this case. But on the envelope, it said that the deed is to be placed in the recorder's office at Erie, Kansas, and to record it. And so after the deed was found, Francis, the brother, was, Dudley, the brother, was notified, and he came in because he lived in Illinois, and he came in and showed up at this residence months later, and Dudley had it recorded at the Neosho County in Kansas, and so Dudley took possession of this land and remained on the land. He lived on the land, but then he sold it to a John Stone. And which happens to be Dudley French was the brother-in-law to John Stone. And Stone actually lived in this house for some time before he, before the house was sold and conveyed. Let's see. He sold and conveyed the land by warranty deed to Stone for the express consideration of $2,000, but for real consideration of only $800, and the land was worth $3,000. At the time, Stone did not know that there was an infirmity in the title of Dudley French. And for the purpose of this case, he must be considered as in fact a bona fide purchaser. So the deed from Dudley to Stone was recorded in June of 1882. And then that summer of 1882, Stone took possession of the land and remained there ever since. 2 years later, all of the heirs of Francis French, including the other brother, Luther French, and Dudley French, were made parties to this action, but and the defendants was John Stone and this Justice of the Peace, S. Michaels. So Dudley died prior to the trial being started. So the case was tried before the court, and the judgment was rendered as everybody got part. So Luther, the other brother, got 1/7 of the property. John Stone got 1/7 of the property, and the remainder of it was to be divided between the defendants. Because the remainder went to the other defendants. So that's when Stone claimed that he was entitled to all the land.
Why? Why did he think that he is entitled to all land?
Well, he felt that it was a valid deed and that all of this should have came to him because it was conveyed to him through Dudley. So now the issue was, did Dudley really possess this land? Was it because the deed was never recorded?
No,
No?
you were almost there.
Okay.
'Cause the
Well,
deed-
it
the
wasn't
deed was
delivered.
recorded.
I'm sorry.
Ah,
The deed
it
was never
delivered.
delivered. So
No, that's not.
okay, so was Dudley
What does
really
lead stand for?
Huh?
Lead.
lead?
When it comes to deeds, I told you have to lead with a deed, right? It has to be lawfully executed and,
Delivered.
right,
Okay. So that's where the issue was on that quarter one.
That's correct.
I'm still not answering the question about the warranty though. I'm going back to, okay. Anyway, so that was the issue on this one. The rule that I got on this one was a deed not delivered but wrongfully in the hands of the apparent grantee without fault or negligence on the part of the owner of the land is unlike a deed not delivered. So, but through the fault or negligence of the owner has been permitted to get into the hands of the apparent grantee. So, on this one, it was, I had the reasoning as the intention of Francis French was that he was to remain the sole owner of this property unless he sold it during his lifetime. This was the first owner, Francis French. But if not, then the property would go to his brother.
Okay, well, just out of curiosity, on the person doing this case, why is that a problem when he writes out, unless I've sold it? Why is that a problem from a viewpoint of just basic contract law? Why would you say whether this deed was even delivered or not, it probably was void anyway? Why?
Okay.
Think about contract law. And deed's just a contract for land, special rules because of that. But again, you never forget your If I write out in a deed and it says, I will give you my land at my death if I still own it.
So
Is
there's a
that,
condition, right? Yeah.
well, but why does that fail as a valid transfer of land? It would fail as a contract. Why?
It's illusory.
It might work as a testamentary document if it's part of a will. That's a little different because testamentaries take over at the time of death. But this was not part of a will. So why is it a matter of contract law that cannot stand?
Is it an illusory?
It's illusory, but why?
There's nothing for you to bargain.
Nope. You can actually pass land as a gift. So
Think timing.
again, another weird
Timing.
timing, right? Very good.
Think timing.
What does that transfer lack?
Think gift,
Not bad. though.
The
Even though
intent to
what
give
it-
it consideration.
it
which is
lacks-
called what?
That's what I was thinking, consideration.
No, consideration has to do with the funds
Issue.
or what you're gonna give in exchange.
What there's no meeting of the minds.
No? So you said intent, what kind of intent?
Present intent.
Present, what kind of intent?
Contractual.
Donative? I mean, I think that maybe that's more gift, but it's effectively that you have the present intent to convey,
Uh-huh,
right?
okay.
And if he's saying, I'll give it to you if I own it at the time, what you're basically saying is, I might give it to you, but I might sell it, I might not have it at the time, I might give it to somebody else at the time. It doesn't mean that you have to sell, you could have given it to change your mind and decided to give it to somebody else. All he was saying was, if I still have it then I'll consider giving it to you.
So is that a valid contract?
No.
Why?
Because
it
there's
lacks
no-
what?
What is it like?
Just basic first year contract law.
What is it like?
You never forget your first year.
Mutual assent.
Telling you.
A mutual assent.
You guys keep picking up here, it's like even down lower than that. Something you probably learned in week 1 or 2.
The consideration?
Nope.
You keep saying consideration,
I know, I keep
like it's
saying
going to,
consider-
like warrants a different response here.
I'm thinking, say it like this, consideration. Okay, it lacks present intent to transfer. Is there such a thing as a contract that lacks present intent to transfer right there, right then? The answer is no. Now, with that said, it is a little confusing. That's why I wanted to bring it out, because in the world of real property, first of all, you can transfer real property without consideration. Strange but true, you can make it a gift, right? That's why people give it property away in their wills. Also, if that contract is part of a will, it falls into the law of testamentary documents. Testamentary documents don't take effect until the person dies. And so therefore, if it was part of a valid will, you can actually do that. But you can't do it during your lifetime that way.
Okay.
So again, very complex little thing, but see, the thing is this is a void contract. And so even if it was proper delivery, can you deliver a void contract? Does that make it all of a sudden not void? No. What if you take a contract that is void from the beginning and then you basically you give it to somebody else anyways and then they record it? Does that somehow make it valid contract all of a sudden? No. So we have a problem here, don't we?
Uh-huh.
They're dealing with a void contract which someone put on recording, which means nothing. It doesn't make it an active contract all of a sudden because someone recorded it. That just means they think they owed it, by the way. Recording doesn't mean you owe property. Most people don't understand that. It's you think you do. And so you're putting the rest of the world on notice that you think you own it. I could go to if you owned property today, I could go look you up and I could put in a deed and say, I own this now. Now, I might end up in jail for fraud, but I can do that. Does that mean that I own it because I recorded that? Of course not. That's nonsense. So again, recording is greatly misunderstood. It doesn't legally mean you owe anything. It's just used as a tactic to tell the world that you have an active claim. Therefore, if you happen to be the first one there, there's a contingent on the other party to prove you don't. That's of course, I already put this down here, so you have to prove that I don't own this. Not that you, and how do you usually prove that? Well, you have to prove the statute. You see, that's actually how the employee works. Doesn't mean you own anything. Just means that you think you do, you're making a claim, and you think people on notice that you're, should you do something to this property, I will make a claim. It's literally all it is. It isn't anymore. It can't be. It's conceptual, but it can't be. I could tomorrow, who has a boom, I could put down a deed right there, I could forge a deed, put it in there to make it valid.
So, do you do recording at like a registry of deeds or something like that, right?
Well, county register.
Yeah. So why aren't there then fail safes like in place to make sure that that doesn't happen, where there isn't a valid contract or a valid deed or whatever?
There are some, okay, and again, like, you know, if they see something that looks really weird, they might flag it, that's true.
But shouldn't there be experts there to make sure that this doesn't?
You know, it's the government, you never know.
That's true.
And would you trust the government expert? Not
It is.
personal, but,
Get a stamp the time.
no. So it really is your job. It'd be nice, don't get me wrong. So you see, this is actually a chock full of cases. So it kind of really shows you how these things work. So what's a partition, by the way? They want the stamp partition. What does that mean? So what do they want in this case? Who wants what? What are they trying to do? This guy says he owns it all. Well, if he owns it all, can you partition it? No. Well, how do you partition it? So what are they trying to do? Think about that. What is the equality? This guy says, I own it all.
Divide it up. Yeah, divide it up.
They want it divided up. How do they want it divided? They didn't think about that. Why do they want it? Do they catch on to that? I mean, this case is just, you gotta really look between the lines on this one. It's a very complex case. Unfortunately, volunteers.
I'm following to the complex case.
A very complex case. What's even the basis of the suit? Did anybody sit down and think, why are they even trying to divide it into 7 elements? What the hell, man? What's going on here? 'Cause again, they don't actually tell you. That's what's kind of weird about it. You just kind of have to say, well, this is something. You have to remember this all. Take a guess.
They have multiple errors.
Yeah, the deed fails, so what happens to it? It goes to intestacy. Goes to intestacy, how many errors does he have? 7. So they want it broken into 7 parts. So the stone is going to get 1/7 no matter what. Because the transfer, because he was a VFP, he didn't know any of this. So he's going to get at least a 7, which is what the French, when the heir before him sold him, so he can sell him 1/7. So you see what they're arguing about was, does he own the whole thing or does he own 7? He's not going away with nothing. But the only part technically, because the deed fails, it goes to intestacy, there's 7 errors. So therefore the person who tried to handle this first thing, actually the minor person that they nailed their nose. Anyway, so there you go. He can only pass what he owns, right? So he definitely owns 1/7 from intestacy, but because the deed fails, he doesn't own the entire 2 That's actually what they're arguing about. So you're the one who's divided. Why is it all or it's not all or nothing, it's all or nothing. So again, you have this interplay between contract law, real property law, and this. Sorry. You guys haven't had rules of trust. How are you supposed to know this? You know what I'm saying? But that's how it's going to be when you get in real property and not the rules of trust. So watch out. But in rules of trust, they actually say the deed went through intestacy. Intestacy at the time said it goes to the I guess it's going to the brothers and the sons and the daughters. I guess is what it's called. So there's 7 of them. That's how it's going to do it. So they're going to take the land and they're going to break it into 7 parts, each one. So he's not completely luck, right? He's not getting the whole 200 acres, but if we do some quick math, he's getting 1/7. I don't know how much that's worth in the houses back. Times the work, actually, but it's not. That's what this case is actually all about. But again, it's one of those really interesting cases, at least from the real property view, because you kind of see this case where we have a situation where, like, you know, again, it's not the easiest case under the sun, but they kind of explain to you why a deed would be void from its get-go. And in this case, it's because it lacks present intent to it, right? Lack of present intent. Then they go into this big argument that even if it wasn't void, it still wouldn't be activated or valid because it lacked actual delivery, delivery. Then the idea, the other thing you really have to take from this case is a void deed that fails because it's void on its face is also, whatever term you want to use, void, still void because it was never delivered anyways, cannot magically be activated because all of a sudden it's been recorded. You know, if you record I can just use the phrase a bad deed, it's still a bad deed. You just recorded it. Spend some money, probably gonna, hopefully you're not defrauding anyone, right? Which we'll see later for sure, but you know, I don't think he defrauded anyone when he did that. So, but that's a lot of stuff. This case is just lots and lots and lots of stuff. And it just goes to show that, you know, how, and, you know, I want to say, well, gee, it's so complex because it's 1887. But the reality would be is, you know, I had a case like this last week. I could have easily said that to you. People still do crazy stuff like this all the time. It's truly unbelievable. So that's why you always, what's the rule? Always get insurance. Always do a title search and always get insurance, okay? Because, you know, again, I'm not saying anyone in this case was good, bad, or indifferent, but here's a fellow I think thought he was going to end up with 200 acres, right?
Yeah.
Did he? No fault of his own, quite frankly. So just you can't sell what you don't own. Right? So this guy had 1/7 of it to sell, and that was it. Okay, so everyone now kind of got this case. Again, very complex case. Recordings and deeds and testamentary documents. This is. But then on the other hand, if you want to do real property, this is where it's at. Yeah. Look at all this stuff, and when you finally figure it out, you're like, look at this. And hopefully, you got the guy. Hopefully, you're representing one of the heirs that's getting 1/7 for that. That'd be kind of sweet. If you're representing Stone, yeah, the news is not so good. Yeah, this for you. So, all right. Okay, well, good job. And again, very, very complex case.
Okay, Earl versus Fisk.
I'll do that one.
Okay.
So Nancy Fisk was the owner of a demanded deed, executed and delivered a deed conveying a life estate and real property to her son and sole heir, Benjamin Fisk, and his wife, Elizabeth Fisk. The deed conveyed fee simple title to Mary Fisk upon the termination of the life estate dated April 22nd, 1864. Nancy Fisk dies in 1865, and unfortunately, the deed had not yet been recorded. In 1866, Benjamin Fisk executed a deed to the plaintiff Earl. Nancy Fisk's original deed was then recorded in 1867. Earl filed a quiet title suit against the defendants, Elizabeth and Mary Fisk. The trial court held that Nancy Fisk had no season at her death, which would descend to Benjamin Fisk, so as to enable him to convey the title to the demanded. As such, a trial court ruled that Benjamin Fisk did not possess good title capable of being conveyed to Earl at the time that Fisk executed the deed to Earl, and Earl appealed. The issue for us is that does an unrecorded deed have any adverse effect upon the rights of bona fide purchaser? And the rule is answered, the issue is answered by the rule, starting in bottom 1144, 1145. At length, says, although an unrecorded deed is binding upon the grantor, his heirs and devisees, and also upon all persons having actual notice of it, is not valid and effectual as against any other persons. As to all such other persons, the unrecorded deed is a mere nullity. It is no conveyance or transfer which the statute recognizes as binding on them, or as having any capacity adversely to affect their rights as purchasers or attaching creditors. So, as argued by the defendant, the unrecorded deed from Nancy Fisk was valid and binding upon herself and her heirs at law, nothing descended from her son Benjamin, and he had no season or title which he could convey to the plaintiff. However, the court disagreed with that argument, stating that the plain meaning of the system of registration provides that a purchaser of land has a right to rely upon the information furnished him by the registry of deeds. Further, in the absence of notice to the contrary, he is justified in taking that information as true and acting upon it accordingly. Here, the plaintiff is in a position to argue that the unrecorded deed had no legal force or effect. That Nancy Fisk died seized that the property descended to Benjamin, her son, and sole heir at law. On that assumption, his deed would take precedence over the unrecorded deed of his mother in exactly the same manner as the deed from his mother in her lifetime would have done over any unrecorded or unknown previous deed from herself. Therefore, the ruling of the trial court was erroneous and the plaintiff's exceptions are sustained. So, judgment is reversed.
Okay, that's pretty good. Not bad. So again, kind of an old case, huh? 1870, you gotta figure that because they use the word deseason about 10 times. You won't really hear anymore. But because this was actually a case for deseason. Actually, the case was for meaning take the land away, being your land being taken away, your land deseasoned. So it's kind of interesting that way.
I always like hearing deceased, and then it's either deceased or diseased, and people get confused, and they're like, are they dying?
Yeah, disease. Who's diseased in this case? Right?
It always amuses me.
Yeah, that's a good one. And so what we have here is, we have a situation where we have a person who did actually receive the land but failed to record it.
Mm-hmm.
And so then we have a person who goes to the registry, an actual person who wants to buy the land, doesn't see the deed because nobody recorded it, right? And then later on finds out that somebody did have a deed that preceded his in this case.
Mm-hmm.
And for some insane reason, as they tell you in the case, the trial court said, oh yeah, that's a good deed, so you have to give the land over. Of course, they say in this case that we've never heard of that before. Actually, an unrecorded deed defeating a bona fide purchaser. That's kind of the big takeaway from this case on 1145. I mean, it's not how it works. And not a difficult case, but again, it's kind of interesting from a public policy viewpoint. On page 1145, if you look at the last paragraph, it gives you an interesting kind of take on it, because everyone always thinks, at least initially, that recording systems are for the benefits of the owners, right? And they're not necessarily. It's really, I mean, it's not that they're not, but it's not just them. It's also third parties who might want to buy land should actually be able to rely on the registry's information as true, right? I mean, you don't, why would, if you could have if you could have an unrecorded deed that all of a sudden took precedent to your sale, why would you ever go to a recording office? Of what value would it be? The answer is none, right? Be zero value because you don't know. You sort of be looking at these gaps in time and you go, even that wouldn't help you that much, right? But anyways, it appears to us that the plain meaning of our system of registration is that a purchaser of land has a right to rely upon the information furnished him by the registry of deeds, and in the absence of notice to the contrary. So again, if you know, you can't, just so we're clear, if you know something, like you're in error and you've seen the document, that's no good. You have actual notice, just so you know. You know, just recording a deed doesn't make it active. It doesn't make it all knowing. It doesn't make it the absolute arbiter. In this type of situation, if the person had seen the grant, right, and they knew that what it was, then that's as good. That's why they say this wouldn't, it would be a little bit different if he was a family member, because it would be assumed he saw the grant, that it would affect his rights, but he's not. He's an outsider. It's partly why he's a bona fide purchaser in this one. So, anyway, contrary, he is justified in taking the information as true and acting upon it accordingly. So what's the rule? Record, right? If you don't record, you're the person who's negligent, right? So that's what they do. Yeah, you agree? Council, you concur? Excellent. So, all right. Wow, it's already 7 o'clock. This class was really fast. Well, in that case, how about Murgis versus Smith? Here's kind of an interesting case. As we're going a little bit of a twist down this one.
Mugas versus Smith, the Supreme Court of Washington, 1949. Facts are Dora Mugas, the plaintiff, acquired a piece of land 135 feet by 3.5 feet by adverse possession that dated back to 1910. By the time the Smiths were the defendants bought the adjoining property in 1941, a marking fence had disintegrated and Dora had stopped using the strip of land. When Smith tried to build the strip, Dora informed Smith that she owned the land and sued them. The trial court ruled in favor of Mugas. They appealed. So she appealed. They appealed. The issue is, does Smith own the property as a bona fide purchaser as the strip of land was not recorded? The holding is no, and the rule is once a person has acquired property by adverse possession, bona fide purchaser acquires the land subject to the adverse possession. So adverse possession is actually the exception to the rule. Doesn't seem fair. And they actually did, the Smiths did have notice. They talked about in the last part of, they said no inquiry was made as to her boundary line before the appellants made the purchase. They were notified as to her claim before doing any work on the strip. So they did have notice of her possession of that strip before they built the building, that house.
Okay. So, okay, but you said that wasn't fair. Did you
It
not?
doesn't sound fair to me.
Why not? I would argue that's completely fair. Things are true. Why do I say that? Now, I could be.
Well, you don't have to record a deed as an adverse possessor, so you have to do more diligence.
You don't have to?
Well, you don't,
Why not?
because you're an adverse possessor.
So
That's not
You
true.
just possess
Why
by-
do you
by
not have,
acquiring
why do you,
land.
when you adversely possess? if
what do you
are
want to
referred-
do?
You want to be there long enough for the statutory period.
And then what?
Do you magically, does a document fall from the sky?
No.
So what are you gonna record?
So if you've adversely possessed and you've met all the requirements, that doesn't mean it's yours.
So why isn't that one of the elements then of adverse possession?
You can adversely possess.
Well, they said that it has to be open and notorious. They said she didn't use the land. She hadn't used the land, but that doesn't still.
We're talking about two different issues.
Okay.
Being an adverse possessor and having title to the property are two different things.
Right. She didn't have
Right?
title.
Yeah.
So how do you get title? What's the term that's used?
We did talk about this. That's
Mhm.
true.
As an adverse possessor?
Yeah. Yes, sorry. I always tell my kids say yes. Court reporters don't like when you say yes. There's a term that we use. So once you have adversely possessed and you can actually take interest or you have an interest in the property now, what would you do in terms of title?
Quiet title.
Correct.
Ooh, very good.
So you go and do that, and then now it's actually you are a title owner of the property.
And they give you a what?
Title.
They give you a deed.
Right.
So you can go file it. Again, it's not easy. I've actually, it's kind of funny, I've actually had to explain that. Don't feel bad if I was a little I've actually had to explain that to clients who had their land adversely possessed, but they never filed anything. Well, that's because a paper doesn't magically fall from the sky when you make the statutory period. You're an adverse possessor because of your rights to possession. Remember, we talked about that, right? You can, that's the one way that you can actually get, ownership by possession. You have to be the owner, just the way it is, right? So anyways, it's an exception to the rule because you actually are adversely in possession. You're fine, but you're not really a true owner until you quiet title. And the reason why is because title is different than adverse possession. It just is, right? I mean, if you think of it as a practical matter, it kind of has to be. Otherwise, how would you even have adverse possession? The answer is you couldn't. If you think about it, not possible. So that's why we have the different exceptions. That's why, to make it legal, so to speak, although again, you're in possession of the land, so no one's kicking you out. The problem is you would also have actually, as a practical matter too, do you know why most people actually do quiet title? It's really not to own it. You already own it. That's not really a problem. But if you want to you better quiet title.
Convey it.
Yeah, if you want to convey though, you do have to quiet title, unless you get someone who'll take a what?
A quick claim deed?
A quick claim deed. You can do it that way. You can go ahead and do that. But then they're going to have to defend your adverse possession claims. I don't know how many people really want to do that, although some do. Every so often you'll see someone who does that spot. So, because again, it's not a general warranty deed, right? You're not promising anyone you're going to defend their rights to anything. So it can be problematic. I mean, again, just as a practical matter, being very practical today for some strange reason. But these things come up all the time, Okay, was there anything else about this case that hit anybody as funny or anything like that? Again, it's just kind of your case about how adverse possession is treated from a viewpoint of recording statutes. Again, it's kind of an oddity because there's nothing to record unless you quiet title. But it doesn't mean you're not in adverse possession of the land. You are. You're just not the title owner at that point. You still have to quiet title. And if you want to convey, again, you don't have to, but I don't think there's too many people who would take your AP claim because you're going to get sued. So, why would you want to defend that? And if you take a claim deed, you walk away with whatever you have. So sorry. And you're always going to get into a fight over what the land is. I wouldn't do that. But none of you will in this class. So crazy. Okay. All right. So anything else about that case? I mean, that's pretty straightforward, right? Okay.
Excuse me, I'm trying to take a charger out of a Mary Poppins bag right now. Everything under the sun is coming out with it. Receipt I've ever had.
Every time I look at a case and in real property and I see Alaska, I always think this has to be good because Alaskans are a little weird about property. So who's got Mortensen versus Ringo?
I'll do it.
Okay.
So Harry McCain conveyed a parcel of real property by deed to E.M. England on February 20th, 1941. The deed to England was recorded, but didn't include an index. McCain conveyed the same parcel of property by deed to Lingo, who's the defendant. Lingo did not find record of the improperly indexed deed to England. So Lingo then conveyed the property to Mortensen, the plaintiff, and England threatened to evict Mortensen from the property, and Mortensen then files suit seeking damages for breach of covenants of title. The issue I have is whether a deed properly recorded in the office of the district where the land lies but not indexed is constructive notice as against subsequent innocent purchasers for value. The rule is a deed that's recorded but not properly indexed is not sufficient to provide constructive notice to a subsequent bona fide purchaser. So Mortensen asserts that the indexing of a recorded deed is separate from the recording process, and therefore Lingo had constructive notice of England's claim upon the property. But Lingo asserts that the Registry of Deeds' failure to properly index England's deed defeats constructive notice, thereby making Lingo a bona fide purchaser against any claim by England. The court talks about a United States Supreme Court case. I have it. There's from 1875, Board of Commissioners for the Sale of School Lands versus Babcock, which held that the index to deeds is not part of the record of deed. But then they talk about a subsequent Washington opinion where the Washington court recognized that as increasing volume of land records accumulate in the public registry of deeds, the index to records is the only practical way of locating records pertaining to a particular piece of property. They say that to rule that the index is not part of the record would require all these prospective purchasers to examine every recorded instrument, and they say when the tempo of life is much faster, the population more transient, and real property transactions occur with such frequency that it takes hundreds of large volumes to contain the records thereof. So it would put an undue burden on every purchaser of land, every bona fide purchaser of land too. So they rule in favor of Lingo.
Okay. So they go for the a deed might as well be buried in the earth of the massive records without a clue to its whereabouts, right? Yeah. So they kind of go for that and say that wouldn't be fair. Okay, now here's an interesting question. Pretty straightforward, right? Everyone gets that. Okay, so what's the law in Alaska today? Is it the same or is it different? Don't look at your book.
I would assume yes.
The answer is no. Now, how do I know that?
50-50 chance.
Now, how do I know that? Because I'm an expert on Alaska law? No, because
Correct.
one of the things that I will be telling you in this class and going forward is do me a favor. Sorry, you got to be the one to get picked on.
That's
but
fair.
always at least read note number 1 after the cases, because it tells you what happens going forward 9 times out of 10. And so it tells you, it actually doesn't tell you, but it does tell you that this is no longer the law in Alaska, that they've changed their mind. And they decided that in fact that would not be the law in Alaska anymore. And then it says, what is the current law in Alaska at the end? But I'm telling you, notes there for reasons, because this is no longer the law. When there was a overruled. They went the entire opposite way. But it does posit an interesting question, which is why did they do that? Anybody want to venture a guess why they decided this wasn't the way to go? I mean, it seems to me that it was, again, pretty fair, right? I mean, if it's not the index, why in the world would you look in the actual rolls? That doesn't really make a whole lot of sense. So why do you think they changed the law though? It's actually kind of a weird reason why.
Technology? Did technology change or something?
Well, partly it was technology. That's true. I think that's true. But what else? What about, how many of you have ever been to there's 2 things that I think the court's trying to force Alaska to do. One of 2 things. What do you think that might be? Just out of curiosity. What do you think? Think about it. What's weird about this? It's always Alaska. Why does Alaska have to do everything so weird? What do you think? Well, let's say that you went to California, and how would you look up title? Would you go to a grantee grantor index? Yes, no, maybe? What do you think? How many different types of indexes are there? How many different types of grantee, grantor, how many different types of recording systems are there? Anyone know? It says in the book, if you read the first part, but no, it did, but that's okay.
Isn't it 3, I think? Yeah.
Well, yeah,
They're
but it's,
classified into 3.
but really as a practical matter, there's 2, and that would be what? How can you look up ownership of property? There's really 2. Think about it. Now, it's not that hard to figure out. You could look it up one of 2 ways if somebody owns a parcel. You could look it up by what or what. There's only 2 things you can look up. Okay, this is not real property. Okay, this is just
Name,
what
this is
you can look up.
Library 101.
Yeah, you can look up the names or you can look up the property. Okay, the track, as we call it, a track index. But that's what you can do. You can look up the name or you can look up the track on which the property sits, most likely through the address, right? Does anyone have a third way? Say some combination of the 2, right? Most states have what? Some combination of the 2. Did Alaska have a combination of the 2? No. So the courts are trying to force the legislator into legislating, why are you using this old stupid method which allows you to do that? Because it's not fair to anybody, so get with it and change the system. So that way you can look it up by grantee, grantor, or you can look it up by track. And you know what else we want you to do? Cross-pollinize. If you did that, you won't have these problems. So do you think that's maybe what the courts are telling them to do? That they're not going to take sides over their incompetence? Just throwing it out there. Anyway, that's why I always say Alaska does things a little different, is what I would say anyway. So yes, that was a very good reading of the case. But what is the rule from now on?
It is constructive notice.
What is the rule in this class from now on? Read note 1.
Oh.
You'll remember that, and I will test you on note 1 again. Don't feel bad because I just nailed the con law class the other day. It's like, how dare you not read note 1 in this class? You have to read note 1 in con law because it always tells you what happened. It's like students ready to, what happened? It's in note 1. You get tired of saying it, you know. That's the wrong one. Now you know. I was going to get a badge that said it's in note 1 at one point in my class I was in.
I'll make you a t-shirt.
Oh, okay. To go with my I own Blackacre. Very cool. Okay, good deal. All right, so well, you guys are doing really great tonight. I mean, you know, if I'm making you read note 1, you guys are doing pretty great cases. So not to be a problem. So I think we have time for one more.
I was like looking at the clock.
Okay, one more.
This is the first one where we get into some serious jurisdictional language. So what you need to understand generally is there are different rules in different jurisdictions. I think that's a pretty common occurrence with law, right? But in this case, we have race notice jurisdictions, we have race jurisdictions, and we have notice jurisdictions, okay? All of them seem pretty similar when you first start looking at the language. So it's important that you are careful about what words are used, okay? So that being said, I will at least help you in this one to identify at the bottom of page 1150, the last paragraph is the jurisdictional language. Okay, so that being said, who would like to take Mortensen versus Lingo? And then I think we'll do that one. When we come back, we'll go over the rules for the different recording jurisdictions, and then we'll kind of continue.
You just say more.
I'm sorry, never mind. having a moment. My apologies. Simmons versus Stun. But on Mortensen, that was the jurisdictional language that was utilized. My fault.
Okay,
No problem.
I'll do this. Another
Wednesday.
time.
No other excuse.
It's a Wednesday moment.
Uh-huh.
I love it.
Okay, this is
Wednesdays are
Simmons
I do
versus
it all
Down.
every day.
This is also an 1882 case. This was a bill to foreclose a mortgage.
Wait, hold on.
Oh.
Did everyone do okay? Okay. See.
Looking right at me the whole time I was
That I
having that
can't
conversation.
Okay, go
You
ahead.
didn't throw me a bone at all.
I wanted to not interrupt you. I lived in 1150 and I was like, okay. I just.
I was like, I'm really like so concerned about this jurisdictional
You should have
language.
picked Papa.
Ugh. That one I would never forget. Okay, I'm sorry,
Okay.
go ahead.
So, this was a bill to foreclose a mortgage, and this was executed on September 22nd, 1874 by an Isaiah McHenry to the compliant of the bill of a John Stun to secure the payment, and there were 7 promissory notes at $100 each, beginning on the first day of March from 1876, every year up until 1882. And which was for 80 acres of land in White County. So the bill was brought to foreclose a mortgage for non-payment of the note due, it was due on March 1st, 1879. And it was alleged in the bill that the mortgage was recorded on March 15th, 1879, and that on November 7th, 1878, Isaiah McHenry conveyed the mortgage premise to a William Cochran and Samuel Strong. That the grantees were informed at the time of the conveyance of the existence of the compliance mortgage and that they took the deed subject to the mortgage. So in the bill that on March 13th, 1879, Cochran and Strong conveyed the premises to an Isabel Simmons, and that the conveyance was made with, here we go, without consideration, and for the purpose of defrauding complainant. So Cochran, Strong, and Isabel Simmons at the mortgage and the mortgager, Isaiah McHenry, were party to the defendants to the bill. So Cochran, Strong, and Simmons answered, putting in an answer to the bill. And the hearing resulted in favor of the complainant. So Isabel Simmons appealed. So the issue was Isabel Simmons on notice or had good reason to know of the existence of the complainant's mortgage as a prudent person on inquiry. So my rule, it's like a one-line rule. I put under our recording laws, the instrument first on record takes priority. So.
Okay.
And but then it talks about the statute, what the statute says, but that's pretty much what it is. It's the instrument is first on record, takes priority.
So this is a notice state, a race notice state, or a race statute state?
This is a race statute. No, it's on notice first. Whoever records first. No, it would be a race statute, wouldn't it?
Yes or no?
Yes, race statute.
Final answer?
Final answer.
Okay, it's race notice, race statute.
It is a
It
race
is a
statute?
race.
Statute? Okay.
Yes, it's just who records
It's
first.
Okay,
This is Illinois in 1882. There are lots of race statutes. back then.
okay, so that's, makes sense. Okay.
Good.
So I have here that, okay, so the court doesn't find it necessary to determine if she knew about this or the existence of the mortgage or not. So what they said was that it had to do with proof in the record that the deed was recorded. But the deed wasn't introduced into the evidence, so the record contained no evidence as to the date the instrument was recorded. So I put down, as the evidence fails to show that the deed was recorded prior to the mortgage, the decree giving the mortgage a prior lien must be affirmed.
Okay,
So that was it.
okay, not bad. Not terribly difficult case. This one, unlike the other one,
I
that
know.
was ridiculously complex. This one's actually simple. It's like, what jurisdiction is it? It's a race district, therefore the first one on file wins. So even though this Simmons transfer came earlier than the later transfer was the one that was recorded first. Therefore, that one takes precedent. So that's just the way it works. I just out of curiosity, would it make any difference to you if you knew that Cochran and Strong were two lawyers? Because they were.
That ups the suspicion.
So it sounds like they're trying to pull a fast one here. And Isabel Simmons, I believe, was one of their sister-in-laws, is what it came out.
Okay.
Yeah, if you kind of read about this case, it's a little, yeah. And of course, they made the transfer for how much?
I thought it was.
How much? What did they charge Isabel? Simmons. Not Isabel, who's in her class. She would never do this. But she had this class.
Because she knows better. I mean, she like fell asleep during negotiations or during signing.
It's a mediation.
Could happen. Those things do drag out.
I don't think they charged her anything.
They charged her.
I don't think I don't think there was anybody on the front that she had to just.
So
go
the
over
answer
mortgage.
is, how much did they charge her?
Zero.
What?
I don't think it was just to take the
So zero.
zero.
Final answer?
Final answer.
Right.
Okay.
They charged her. So how can she be a BFP? She paid value? The land was worth nothing. Okay, were these smart lawyers? No! That's what I'm trying to bring out. They're stupid. They don't charge her anything. They try to make her a BFP. In fact, they never recorded it. They're just claiming they have this crazy deed. Okay, just wanted to point that out.
I know.
Now, before we leave this case up, I do have one more question for you. What type of state is California? Don't look in your book. Don't look it up online. What kind of state is California? No. There's only three.
Race guns,
Okay, it's race notice. How do
Why?
you know that?
I don't like this.
Okay, now, here's my point. If you read note number 2, it tells you.
Well, aside from the fact that California always seems to be a hybrid state,
Always go for the.
it's always safe to say California is going to dip into both categories. Okay? Anybody? We good? All right. Why don't we come back at quarter till?
Good job.
We'll get into a little discussion about the rules so it's a little clearer. And then
It's not easy stuff.
we won't melt.
Good job, though. The race statutes.
Kim Kardashian, 2 seconds on what?
You know she's in Australia.
Oh my gosh.
We just.
Somebody told me
We had
that.
this whole conversation.
I was like, what?
We had that conversation.
They were like,
I didn't even know that. I'm in shock. I didn't even know she could read.
Well, we need to read this stuff. Despite their media. Image. They try to keep up their image. Otherwise, some companies are.
I mean, her dad was from her connection.
Yeah,
Maybe
Robert-
it's.
He
Oh,
almost,
that's true.
he almost lost. Wasn't this true though? Almost. License was removed.
Still passed the bar, so. No, I'm saying, he still passed the bar.
I thought he
He
was,
was-
I thought I heard that.
He's legit enough to.
Because he wasn't practicing, he wasn't
Yeah.
practicing when he, represented Pujo.
He wasn't practicing.
He was doing entertainment, wasn't he? Robert Kardashian.
Yeah, Robert Kardashian was a famous entertainment lawyer, and then he kind of ruined his career when he signed on to help represent OJ from alongside. He's supposedly the one that, to this day, they claim that there's a, for better or for worse, they claim that he's the guy that got the knife from OJ and he put it in the safe deposit box. And then it does exist. And if it wasn't, again, nothing personal, like Steve Hill of the dead, but Robert Kardashian, he do it.
Remember the look on his face when they announced the verdict? It's just.
He was extremely not believe.
Well, all of them were incomplete.
Yeah, right.
And I read that later, none of them believed he was.
Yeah.
Kind of
Shocked.
She said that I would have been horrible. Sister.
You have an extra one of the, instruction sheets,
I'm sorry.
one of these, do you have another one of these?
Yeah, sure. You can have mine. I have the originals.
So, what are you doing next week? What are you doing?
What I'm doing next week?
Yeah, spring work.
Hmm?
Spring break.
Oh, I know, but not, I don't work.
We're all in agreement.
Yeah,
Just the break from classes.
teacher, if you're a teacher, you get off.
Oh, it's funny
Right.
because I shouldn't say it. It's interesting to say that because his mom was a substitute teacher.
Oh,
That's weird.
bless you.
No, I can't.
Oh.
But she had that, benefit.
Oh, right.
Yeah, then the big boy came around. She's already done with like school year.
Yeah.
So she already had a 2 weeks or more.
Oh,
I'm like,
right.
damn. I'm like,
Yeah,
oh
teachers have a
no.
lot of time off, you know?
I think they should.
Think they should?
I think they should. They babysit on top of like teaching.
Yeah, especially today versus years ago.
I'm seeing so many videos about. I'm not saying that it happens at all schools, but I'm like, dude, you're not paid to babysit. That sucks.
Yeah.
But my thoughts. But I do think there's people who do need it. Forensic psychologists. Oh my god, the things you hear though, and like the people you deal with.
I know.
You gotta take a break or you get crazy.
Hmm?
You gotta take a break or you go.
Yeah,
Especially if you have the sexual clients.
yeah.
Things you hear all day. Oh man, I can't imagine.
Well, did you want to be a forensic psychologist? or-
No, maybe psychology in the field. Way back when.
Yeah.
I don't know. I don't think I have patience anymore for that.
You know what? I always want to be a prosecutor.
Yeah.
And then as life continued,
It's not as black and white.
yeah, and I
Right.
just got, I developed so much passion for people.
Yeah.
But I just thought, I don't think I could, I don't think I want that responsibility of putting someone behind bars.
Yeah.
Okay, I don't know about their past,
Yeah. I think if you're gonna be a prosecutor, you really need to go by the book. If you
Yeah.
got rules, you can't evidence, all that stuff.
Yeah.
If you want to really got to do it right. Otherwise, 90%,
Yeah.
in accordance with the law. Despite what you feel and you think that they did.
Yeah.
Crazy.
Hmm?
It's crazy.
Yeah.
Sorry. And I'm seeing like in mind is like to lock up the wrong person.
That's what I'm saying, like, years ago.
Yeah.
I didn't even hear about that. I just, you're arrested.
Mhm.
So I'm getting my schedule for next week.
That happens.
So tomorrow, maybe we could book a day next week.
Okay,
Or we
I'm
could
gonna
get
be
together.
here, they're gonna have something on Friday. I guess they're doing a baby born review or something like that, so I'm gonna be here
They
Friday.
told me.
I think Kelly told me, I gotta ask her,
Yeah.
so,
But the
Um,
chance
I'm
Well,
gonna
let
be
me know.
here,
Yeah.
yeah, I'm gonna be here all day Friday and Saturday,
like how they.
Oh, well, let's,
Yeah.
talk on Saturday. Well,
and then
Come on.
all next week, whatever
I'll
day.
Yeah, 'cause I-
was on the prosecutor's side.
my days are
Yeah, you can
not
really-
slow, they're filling up.
Yeah.
Okay,
But well, I don't think I'll be here no, I can't be here on Friday. actually,
Okay.
So I have a thing on Friday.
okay,
Okay, but we'll talk on either Saturday or whatever.
okay, and I'll be here all day Saturday, so whatever day next week is fine with me. I'm
Yeah,
ready.
because by Saturday I'll know.
Okay.
So,
That's
yeah,
good,
because I just getting better.
okay.
I still get nerves sometimes.
Yeah.
But you got
Did you?
wait and see.
You know, it's kind
You wait and see.
No.
There's
There's a saying. What is it called? I saw on the show. It's like, bad guys gotta do bad things to put the bad guys away. Or something. Good guys gotta do bad things to put the bad guys away. It's like the thing. I'm like, oh, that makes a lot of sense. But this, no, you can't do that.
Yeah, especially it's not.
Yeah, so you don't feel okay. Yeah, who knows? But we're dealing with this interesting case right now. This is buffet. They got caught, they're allegedly apparently dealing in their restaurant. So they got their house raided and everything. And like, I'm talking, just, Mike barely told me about it, I'm like, but like, where's the evidence? Like, come on, how the heck?
So is Mike doing criminal also? I thought he was just doing family. So
Well,
he's doing a bit of everything?
not mainly like DV is like the closest he would say is domestic violence, but that's not at all. But then other cases we're doing, one big one, like civil forfeiture, I think that's a big one. I have to read this case on it, that's pretty into the case, we'll see how it goes. But it's gosh, no, this one, for instance, they got caught, apparently all the money was in the house, and so basically they tied.
You guys finished?
No.
Are
Take a break.
you
Halfway.
serious?
We have like long days,
With that?
long nights now. We recording these, yeah.
What
It's a 12 case night.
How many cases have you done?
Six.
Double up. Speed
Read
it up.
fast.
You hungry?
Bit,
We're
bit.
gonna cut our.
You don't even take a break. You don't even take them anyway.
Yeah, so like a ton of their cash that they failed to deposit. It was legitimate cash, not even like belonging to the whole restaurant, was totally raided, and now it's like the DA's not giving it back.
Really?
Is that what civil forfeiture is?
No, if you don't win it criminally, like civil forfeiture, I mean there's burdens of proof. I mean it's very, very low for civil law.
So technically you're going after the DA.
You know, like they're gonna go after it once criminally, if they don't have a case for that, they're probably still, you know, civilly, they're still gonna go after it like the OJ.
Oh, right,
Yeah,
yeah.
some people understand the concept,
Yeah.
but yeah, I don't lose a lot.
Yeah.
Going home?
Yep, running out. I'm running away from home.
Let's do that. I think we should do that. I don't know. I'll tell you more about it. It's interesting. It's like, because it's a restaurant I've been to, like that
Oh,
that
wow.
Chinese buffet down 111 near the Ford dealership.
Where,
Something,
down, what city?
right up Cat City, going towards Retro.
Oh, Cat City.
I've been there, and I'm
I
thinking, dang,
remember-
that's sad.
My son one time, because he's a paramedic, and he was working for a private ambulance company out in LA. And he went on a call, because they get called out, so when he came back,
Mhm.
he's the one in the back of the ambulance, because he's a paramedic, so the EMT driving stopped, and he goes, what's going on? And he goes, look, so my son takes out his camera and starts filming, and there's a bunch of guys in suits going into the place, and he sends it to me, and I,
In the restaurant?
going into the ambulance facility,
Oh.
and he sends it to me, and I said, get out of there, those are the feds, I don't know what's going on, and they were walking out with the computers, and the guys, the owners were handcuffed and everything, they were defrauding Medicare.
Oh, no fuck.
They were, you know how they can charge them,
Yeah.
their Medicare patient and
Yeah.
things like that.
They just charge for a procedure they didn't
They
do.
were,
Yeah, yeah.
yes, they were different, and I said, get out of there, come home, look for another job,
Yeah.
cause that place is done.
Yeah.
You know,
God, that's terrible. So what did he?
and they were,
Well, they probably
I know
interviewed
I know it's Kardashians, they were Armenian owner. And I was like, and this, one of the guys that was doing the book work, he had to hide out in Newport with the girlfriend because he was family, and he was actually gonna be one of the witnesses, and the FBI was looking for him because they were gonna get rid of him.
You know what's that's interesting to me. Mike put up this interesting thing. He's like, you gotta do everything by luck as a lawyer, especially if it's sole proprietor, because you can get hit with that. And he's like, I spent way too much time and effort to get my law degree for them to like just take it away from me.
Right.
Like you spend all this time like stuff with business. It's legitimate, right? And yet you're defrauding to get more.
That's
like,
just-
dude, you're done.
You heard about what they said yesterday about the guy out in the attorney out in New York who losing.
Oh, yeah, like he's like the head of their business.
Yeah, that is the
Yeah.
Because he paid a school, now
Yeah.
he's losing his license.
Yeah.
He's got fired.
Yeah.
He's,
Yeah.
I mean,
Well,
It's, isn't,
Well,
can you
you do.
imagine, I mean, again, see, the weird thing about me, I even have compassion for those people who are the cheaters, because I'm like, imagine,
Yeah.
first of all, they didn't kill anybody, they didn't, I mean, they, all those, they're trying to help their son or their daughter, right? I'm not saying they were totally illegal what they did, I just can't imagine what they have was going through their head.
okay, so did you hear about some of the parents, there's a couple of parents that are suing, that Lori Laughlin?
Yeah.
Because
what?
of what she did, it bumped down their kids, so their kid couldn't get into USC because of them. So now the mom is suing her because of what she did, because now her daughter had to go
What was
someplace
the
else.
cause of action? Like intentional interference, contractual
Well,
relations?
because now it's a criminal thing, so she's,
Yeah.
because of what she did,
Yeah.
now what's this, what is that, what are the damages, like, she lost all her schooling from USC, she had to go someplace else, she could have been making, doing good and having a good, rapport with USC and on the resume and all this other stuff. And she didn't even make it because somebody else bumped her out, and that was
Yeah.
Wait, was she like on track to go to USC or?
yeah,
was
she had took the test and everything, and
Yeah,
and you
she
can
had
only, you only take so
acceptance?
many people in.
Right,
I mean,
right.
she can't prove, she's not gonna be able to prove that it was actually Lori Laughlin's daughter, but it's a generic
Yeah,
assertion that, hey, what you did, you bumped other students.
Yeah.
Or however.
you
many
bumped
students.
other students,
So
so
it's
she's,
like-
she's suing, I don't know if it's
No,
correct,
I
but
think
it's
she
just
did a
the,
class action.
it's just the stress.
Yeah, I'm like,
Yeah.
Yeah,
I think
she
that's
should,
fair.
I think it's like $500 million.
Yeah, I think that's
Yeah,
something
but it's
She's
just
like
the
a big
stress
business.
of going, even if you don't win, it's the other person, the stress of having to deal with that.
I just can't imagine, what I mean,
And now everybody's suing.
to be that irresponsible, to give up, to risk giving up all that you just, what Mike is saying, right?
Yeah.
To risk
Everything you've worked
everything you work for,
for
because,
years.
but it's kind of like that whole, power corrupts absolutely, and absolute power corrupts.
Mhm.
Yeah.
Because it's like when these people, I'm sure this is not their first rodeo with something illegal, they gain all this power and they get so used to being entitled and, they're
Yeah,
so
take
powerful.
whatever they want.
They take whatever they want, and they just, they probably get away with little things all along the way. I mean, I talk about psychology, I've read like 2 books on sociopaths because I dated one, but there are many CEOs of companies who are sociopaths because they'll do whatever it takes to step over people,
Oh, yeah, they do,
So people always think it's like
they do.
the sociopaths are criminal in like they're the ones that are in prison and murder, but it's a lot of white collar sociopaths out there.
Yeah.
They're entitled, they think that they're,
And
better
they're quick to point the finger
Yeah.
to somebody else.
Yeah, that's what I heard.
To the,
Sorry.
I always call it the little man,
yeah.
I always point it to them.
They justify their actions
Mhm.
a lot.
And a
Right,
lot
that's
of
what
them,
they
and a
justify.
lot of
So,
them are covered.
And the
now.
rules don't apply to them, that's
Yeah.
classic
that's-
sociopath.
Yeah, but you know
Rules don't
what,
apply to them.
things are changing now, because years ago they got away with a lot of this stuff, now they're not
I
getting away
know,
with
it's
it.
interesting how,
They're coming after them.
it's interesting how like the Me Too movement and then this movement is like,
Oh, yeah, they're coming.
people are coming down on these people who
Yeah.
think that they, because of their power, that they hold, whether it's fame or whether it's fortune, you know what? You're just like everybody else.
And they're not gonna be able to handle it.
Yeah.
Mhm.
I wonder why, you wonder like, why did Lori Laughlin's attorneys? I would assume that I don't know, of course I don't know, but, why did they pressure her to do a plea deal? Like, maybe they did, and she just is like, no,
She's probably arrogant though too, because they said that she went in there like and shaking the hands of people and like, some people are like, I'm a celebrity and look at,
right,
nothing's gonna happen. But boy, that changed real quick,
yeah,
so. Just so happens that they're the ones that are in the media all the time, on the news and everything, because there's like 13 or
yeah,
14 families that have done this.
Right,
You
yeah.
know, They're
And
not
if they
showing
both go
the
to
way.
prison, are they gonna be in prison at the same time and?
Cause
Daughters.
Yale's involved in it.
Stanford.
Stanford.
See,
I heard somebody's kid, they took, wiped out their grades and everything, so they won't.
They have proctors already.
Technically, they
people
never even
sucks.
showed school, they never even went to school.
Man, I'm just glad I'm not them, I'll be honest with you guys.
Huh?
I'm just glad I'm not them.
Mm-hmm.
I mean,
You what?
I'm not them.
Mm-hmm.
I'm not, they're not my parents, I'm not that student.
I know.
Because-
Too.
When you say, more money, more problems, the more money you have, the bigger problem you get yourself into.
You know what?
White collar crime wise.
Yeah.
It's true, and the more money you have, the more people come and try to get money.
Yeah.
I have so much problems. I mean, it's just, my uncle owned a restaurant, and they were constant. It wasn't a little restaurant. It was, we sold it. I think we sold it for $1.3 million.
It's been successful.
And they have he gets people all the time coming out there. and
Yeah.
asking for
Oh, I
money.
know, the lottery ones, right? I mean,
And now where his house is at, it's on the border of where the San Manuel Indians live. So they're trying to buy him out. So, and he keeps saying no. So they keep upping the money and he keeps saying no. And I'm
Does he
like,
want to stay or does he want to keep upping it?
he's fine. He doesn't need the money. He's just sitting around saying no.
Oh.
He just likes to say no.
It's like
Piss off
that-
everybody.
It's like that guy, what he's like, the movie with the balloon.
The balloons,
Is it
yeah.
called?
I saw that. It's a little cartoon.
It's like,
Oh, yeah?
We're missing like.
oh man. Yeah, so he buys the land, buys that house with his wife, which passes away. Years later, of course, but everything changes around him, but his small little house. Remember the movie Up?
Yes,
Yeah.
kind of.
Kind of.
Like I watched it in the background. I probably put it on so then the kids could really enjoy it. And sometimes I'll sit with them for part of it and then I'll be like, ooh, there's laundry. Or like other stuff. You know how you hit that very adult part of your life when you're like, okay, the kids are gonna be with grandma today. I could organize my closet. Or I could put away, reorganize the pantry or do laundry or get to all of my errands at once.
That's fine.
And then I'm just like, oh my God, I need a day to rest. Because that is my hey, I've got time off day.
Let's do stuff.
Yeah. Because then you just feel guilty while you're laying there watching diners, drive-ins, and dives for 7 hours straight.
I have never.
I heard that guy's a dick.
I heard that too.
Yeah.
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 And I heard he gets exponentially worse when he has some alcohol in him.
Guys.
Yeah.
Oh yeah.
He has a restaurant in Vegas.
He's got restaurants all over the place.
Guy,
Fieri.
Oh, God, yeah. Why does everybody give him so much crap?
Well, I think we're just saying we've heard that he's a bit of a JRK. I guess I don't need to spell for you guys, but sorry. Guy Fieri.
Oh, I heard he's a butcher.
Yeah.
I hear his place.
Did you hear Kim Kardashian's going to law school?
Oh, yeah.
Oh,
I know I did.
So no joke, we were talking about it and I was looking down because I was writing at the same time. I didn't see you walk in and then we literally had just finished talking about it. She's like, did you hear Kim's gonna take the baby bar? And I was like, am I missing something? Did I just have a time lapse? Did I just hallucinate that entire conversation? They're like, no, she walked in. We were looking down and I was like, and then we sat here and then you came in and you were like, the Kim Kardashian's
Wow.
Yep,
Okay, got it.
that's what I heard.
Yeah.
You know what's funny? Our students are probably gonna be sitting next to her because it's unlikely that she's gonna be taking it in a separate location and,
If she asked for accommodations.
Yeah,
Yeah.
oh, maybe that's true. Yeah, she'll probably ask for
Who knows? She
I
can
don't know.
always check in with Felicity Huffman.
Yeah, right.
And have all the media.
Hey, you know,
I'll
John,
walk by.
accommodations,
Yeah.
just get to the room with everyone else in
Does anybody watch Shameless?
Mm.
Yeah, okay, so in Shameless, William H. Macy's son, Philip, used to take SAT exams for other students.
Yeah.
He would go and like pretend that he was them.
Okay.
So it was like ironic that like
Oh my God.
they were involved in
Oh
this.
my God.
Yeah,
Yeah.
William and, wait,
So William H. Macy and Felicity Huffman. So Felicity Huffman was indicted for being part of this college, yeah. This like college thing, and so when on the show that he's on, one of his sons on the show, his character would take exams for people because he's like super smart, and he basically just go in there and like crank it out for them so they get a better score.
wow. That's
I
weird. I like that
I
one.
wanna do tests for other people.
You don't watch Shameless? No.
No, there's like that concept. I know in real life people actually did,
Because they paid him.
so we can't be.
Oh, back in the day,
Well,
I
I
had
guess
people off.
They're talking about big
to take
fun
their-
stuff.
Really?
Yeah, way back when.
I used to hear
I was like,
Well, I mean, these are celebrities, so
what
they.
they do that for?
We had 2 people kicked out of the bar exam. One, I heard afterwards, one person went and tried to make a phone call to ask about something, and I was like, you have text message. First of all, you're not supposed to have your phone, but like if you're going to be that stupid, be discreet. This is my feeling. If you're going to do something wrong, at least don't be sloppy. You know what I'm saying? So then the other person apparently kept going back and forth so often that they asked if they had some kind of an issue, like if they were having a medical issue, or they kept going back and forth to the bathroom. Well, apparently they had notes tucked in like to their shirt or pants or something, and were taking them out and like reading them and then going back in. So yeah. There's always a story from the bar exam. My best friend took the bar exam before I did, and somebody had like a heart attack in the middle of lunch, or like probably a panic attack during the lunch hour on the last day of the bar.
Oh, so close.
Mhm.
Bummer.
So
It's gonna be me.
such is life. They always used to say, like, if somebody starts flipping out or some has a seizure, or God forbid something happens, there's a medical emergency, you keep typing.
Wow.
And like but I mean, realistically, that's why they have staff there. That's not why they have staff there, but that is one of the things that staff should be managing, not the participants. But I mean, like, if Doug Rogers like sitting next to the person and he doesn't help and like looks really bad, he would help. But then he'd be like, okay, take them. They're disabled, I gotta go. Which is what you should do. You take your exam. So, that sounded very cold, but it wasn't meant to be. But it kind of was. Okay. So, let's talk about recording statutes, okay? Generally here's how we would discuss some of these rules. If B is a bona fide purchaser and we are in a notice jurisdiction, okay? B wins regardless of whether or not she records before A does. Okay? Why?
Because the statute protects the bona fide purchaser.
Right. And they're the newest bona fide purchaser in time, effectively, right? So, if B is a bona fide purchaser and we are in a race notice jurisdiction, B wins if she records properly before A does. Okay? Recording acts exist to protect only bona fide purchasers and mortgagees or creditors, right? That's not bona fide purchasers, mortgagees, or creditors. That is bona fide purchasers and mortgagees. Mortgagees are also known as creditors, okay? That was my way of doing parentheses. Not like air quotes, but arm parentheses, okay? Anybody Friends fans? Okay, so my favorite was when Joey would just start using air quotes. And you're like, yeah, but that's just like, you saying air quotes does not warrant you using air quotes. She looks really pretty today. No. If you're saying she actually looked pretty, you don't use air quotes. It doesn't make any sense. So I always like to think of that. Okay, so now, what is a bona fide purchaser, right? Bona fide purchaser buys Blackacre for value, and purchase will be for value as long as it is what? Substantial pecuniary consideration. So, valuable consideration. Okay? Recording statutes do not protect donees, devisees, or heirs unless what? Anybody familiar with the shelter rule? Okay, unless the shelter rule applies, the shelter rule would then effectively put you in the shoes of the party that was the bona fide purchaser. Okay? So, bona fide purchaser buys Blackacre for value and without notice that someone got there first. Okay? Everybody get that? Those are the two elements for a bona fide purchaser. Now, 3 types of notice again, right? Heir, actual. Prior to B's closing, B learns of A. Does everybody get that? You good?
Yeah.
That was like a heavy sigh.
No, yeah, I'm good.
Okay, just a little confusing.
No, I'm good.
Okay, cool. All right, inquiry notice. Whether he looks or not, B is on inquiry notice of anything that an exam of Blackacre would show. So, what do you not want to do if you are required to do your due diligence on inquiry notice? You don't want to buy a property sight unseen, right? People do that all the time. It's very bizarre to me. But I suppose those are people who are probably independently wealthy and just deal in real estate transactions frequently. So,
Let's see.
let's see. So, under inquiry notice, buyers of real estate has a duty to inspect before transfer of title to see whether anyone else is in possession. Seems reasonable, doesn't it? Do your due diligence. Now you got me going. It's like yawning. Okay. If another person is in possession, B has inquiry notice regardless of whether B actually bothered to inspect or not. Okay? Again, they should do their due diligence. Also, if a recorded instrument makes reference to an unrecorded transaction, grantee is on inquiry notice of whatever a reasonable follow-up would show. Got me? If they see something that says, hey, there was some break in this title, there was some unrecorded title, and you don't go and at least investigate that, inquiry notice is a form of constructive notice. So they're basically saying, inquiry notice is, do your due diligence notice. Do what any reasonable landowner would do notice. Does that make sense? Okay. Record notice. B is on record notice of A's deed if at the time that B takes, A's deed was properly recorded. Okay? Because what can you simply do?
Look it up.
Go do title search, right? Oh geez, there it is. Now, if you did that and you went to the property and you didn't have any actual notice, then you could be a righteous bona fide purchaser, right? So now let's get into the recording statutes. Notice statute, okay? A conveyance of an interest in land shall not be valid against any subsequent purchaser for value without notice thereof unless the conveyance is recorded. So if at any time B takes, he is a bona fide purchaser, then he wins in a notice statute or in a notice jurisdiction. Do you understand that? If at any time B takes and he is a bona fide purchaser, he wins. It won't matter that A may ultimately record first before B does. It won't matter in the A versus B contest that B never records. It's not about recording there. Now, with the exception that if B takes and it was already recorded, I'm sorry, if A takes and B somehow already recorded, which logistically can't happen, right? A can't take after B has already taken. Does that make sense? So, effectively, it's not a matter of recording or timing of recording. It is a matter of whether or not B takes as a bona fide purchaser. Because if they do that, they are effectively the one with clean hands in this situation. You cannot be a fraudulent bona fide purchaser, right? Has to be taken without notice that someone got there first and for valuable consideration. So, let's talk about a race notice statute. Any conveyance of an interest in the land shall not be valid against any subsequent purchaser for value without notice thereof, whose conveyance is first recorded. So in this one, you not only have to be a bona fide purchaser, but you must record first. Got me? Notice statute, you just have to be a bona fide purchaser. Doesn't matter if you record first, doesn't matter if you don't. Race notice, you must be a bona fide purchaser, plus you must record first. So to prevail here, again, must be bona fide purchaser, and you win the race to record. In order to give record notice to subsequent takers, the deed must be recorded properly within the chain of title. This refers to the sequence of record documents, okay? In most states, the chain of title is established through a title search of the grantor-grantee index. Okay, we talked about earlier how bona fide purchaser must have paid some substantial pecuniary consideration, right? And I talked about the shelter rule. So let's get into that a little bit, because this is exactly why if the shelter rule doesn't exist in your jurisdiction, you can't be a bona fide purchaser because you have not paid valuable consideration. And that is a requirement of being a bona fide purchaser, unless you fall into a shelter rule jurisdiction. One who takes from a bona fide purchaser, so you first have to find that the person that owned it was a bona fide purchaser. If you take from them, you will prevail against any entity the transferor bona fide purchaser would have prevailed against. Let me say that a little bit more clearly. BFP owns the property, right? If BFP then gives the property by way of devise to a devisee, a donee, or an heir, okay, that person didn't pay for it, but they should be treated under the shelter rule the same as the transferor BFP. So same as BFP, right? The person who gets it from BFP should be treated the same way under the shelter rule. Effectively, this means the transferee takes shelter in the status of the transferor. So the transferee basically takes shelter in the status of the BFP. And that's why I say they effectively step into the shoes of the BFP, even though they would otherwise fail to meet the requirements of BFP status, right? Because they didn't pay, okay? All right, so let's talk about a different issue with deeds, okay? this may be a bit premature right now, but I just wanna kind of get everybody's head wrapped around this. Why the record is so important, okay? If O sells Blackacre to A, okay? And A does not record, then A sells to B, and B records the A to B deed, right? Everybody get that? So let's write this up. It's a little easier sometimes for visual learners, okay? O to A. A does not record, okay? Then A to B, B records, okay? The A to B deed, although recorded, right, is not connected to the chain of title because the O to A link is missing from the record. The A to B deed is what we call a wild deed. Let me show this to you in a different way, okay? Everybody's familiar with the chain, right? That's the best you're gonna get for me. I did not have a fine arts degree, okay? So, this is O to A, okay? Actually, hold on, that's not true. Okay. Here is O to A, okay? Here is A to B. This is effectively, no, don't want to do that, sorry. Oh, fail, O to, okay. This deed is not recorded, right? So if this is not recorded, but this is recorded here, we have this that actually connects. I'm gonna mess this up again. Okay, so I'm gonna do it a different way. This connection effectively doesn't exist. So all that you have notice of is that O owned it at one time, and then somehow it ended up with B because of the A to B deed. The question is, how did A get it? If you're looking at this on paper, right? How does A get it? Because all we know is it went from O to B by way of A, but we don't know how A got the deed. Okay, so wild deed. They lost the chain there. Okay, so if the deed entered on the records A to B has a grantor unconnected to the chain of title from O to A, the deed is a wild deed. It is incapable of giving record notice of its existence. So this is the argument you'd want to make on behalf of the BFP. I couldn't know because it's a wild deed. Right? Okay. Keep kicking this thing. It is injuring me. It's not a good look. Okay, hold on.
Did you say it was incapable of giving record notice?
Yep. Mm-hmm. Okay, so last one. And I think I brought this up last week. I know I brought this up last week. Estoppel by deed. We're all familiar with the idea of estoppel, correct? Okay, now let's slightly transition that. One who conveys realty in which he has no interest, right? So you hear me? One who conveys property in which he has no interest, because we were talking about covenants, remember last week? And I was saying they have the right to convey, and covenant of season, they actually own it, right? So the guy that conveys something he doesn't have interest in, but then later acquires interest that was previously transferred, is estopped from denying the validity of the conveyance. Does that make sense? So let's look at this. Timeline, this is more of a chronological issue, okay? So O to A, except O really didn't own it at the time. Okay? So O doesn't actually own it. At some point here, O actually acquires interest that he didn't actually have when he conveyed it to A. But does O get to go back and say, hey, this shouldn't actually count because I didn't have it at the time, so it's really still mine? No. They basically are stopped from denying the validity of the conveyance. So they basically have to pass it forward so that even here, A is going to own it. Okay? So it's kind of like, it would be like a shicey thing of, all right, you transfer me the title, but it's after I transfer it to them. So then it looks a little like, you know, if I didn't own it, how could I transfer it, right? But what they're saying is you made an agreement to transfer your interest in it. And I'm sure the sad part is some, you know, bad apple spoiled the bunch or spoiled it for everybody else, right? So O at some point was like, hey, I could probably retain ownership if I transfer whatever interest I own, and I don't really own it. Even if this was by quitclaim deed, A would have a tremendous argument to say, look, you conveyed to me the interest for Blackacre, and even though you didn't have it at the time, you knew you were conveying the interest to Blackacre, and now you have the interest in Blackacre. That's mine. You have to be reasonable about passing it forward. That makes sense? Anybody not get that concept? Okay. So basically it's a make good on the commitments that you've already made. Got me?
Only took 2 seconds.
What?
It only took 2 seconds.
Right? You and Kim. You and Kim. All right. Your dad does one OJ trial and all of a sudden you're a legal genius. I mean, if she does well, I hope she does. She's got a great platform to do some good things, but I think the narcissism and the cavalier way that she discussed the study and practice of law was probably it was very off-putting. That did not make me want to support her. It made me feel like you don't really take this seriously because it doesn't sound like you really are putting in the time. It sounds like somebody's collecting it all and explaining it to you because you don't like doing the hard work, which is the reading and the analysis and all that stuff. That's, I think, why it was very off-putting to a lot of people. But at the same time, then I feel bad for not being like, hey, go get him. Like, do your thing. That's wonderful, especially as a law professor. You know, I want to support people to do that. I just don't want people to act like this is no big deal. And why doesn't everybody else just get this 2 seconds? Like, what's wrong with you? It was kind of the vibe I got from it. Could have just read completely into it, but I don't think I'm the only one that felt that way. Sorry. Rage!
Does everyone know that Kanye is going to be broadcast live from Coachella?
For Sunday service. I did like the part about where she said he's bipolar, but doesn't really subscribe to taking medication.
Oh, well.
I'm sure there's a lot of people that don't that are bipolar. And
Oh, she can love them.
maybe he's a Gemini. All right, so that's basically an overview of the rules of deed and kind of some of the issues that we'll see when it comes to deed. So let's kind of bounce back into our cases now, because I think we still have a number of cases to go. Did we do Stimmons versus Stone?
Yes.
Yes, that was the last one, right?
Maybe she would have Kanye as a client.
Most of my clients are defendants, so that would make sense to me, but Mhm.
Plaintiff and defendant.
Oh, yeah. That would be weird. And
But he can sue himself.
he could.
I hate you. Sue you. Oh no, don't do that. Let's settle.
So, we talk about persons protected by the system. Again, remember, bona fide or recording statutes are really there to protect the bona fide purchaser and mortgagees. So, understanding that, who would like to do Eastwood versus Shed?
Okay, so on December 2nd, 1958, Cleo Alexander deeded the property to Eastwood, who did not record the instrument until October 16th of 64. On October 15th, 1963, just a year prior, Mrs. Alexander executed a warranty deed to her daughter Shed, who recorded the deed on October 23rd, 1963. Shed did not have any actual or constructive notice on the prior deed to the defendant until it was recorded the next year. So Shed sued Eastwood for quiet title to the court, and the court held for Shed, so Eastwood appealed. The issue is all caps, so it says, is the donee of real property who has duly recorded the instrument of conveyance entitled to the protection of the provisions of CRS 1963 11-6-9 of the Colorado Conveyancing and Reporting Act. So the rule I have is on page 1159, where it says, stricken from the former act were the words shall take effect as to subsequent bona fide purchasers and encumbrances by mortgage, judgment, or otherwise not having notice thereof, and substituted therefore were the words shall be valid as against any class of persons with any kind of right. So here the issue is whether she was still protected because it was gifted, she didn't purchase the land. So it says, but here the court upheld the Colorado statute which said that when property is conveyed to a second grantee with no notice of the prior conveyance and then records the deed before the prior conveyance, then it takes priority. Colorado statute is described as a race notice statute and it gives the bona fide purchaser reference. Here, Eastwood argues that the statute only protects bona fide purchases and Shed received the land by gift, and argues that a majority of the states protect bona fide purchasers for value. Here, however, the court said that Colorado expressly changed the language to protect any class of persons with any kind of rights, so it affirms it. Trial court decision.
Pretty good. So, are persons who are donees in Colorado protected by the VFB statute?
Yes.
Everyone agree? Can they do that? Sure, why not? Okay, moving on. Pretty straightforward case.
Okay, Strong versus Weimar.
Yeah,
Why? Because I can't.
Strong versus Weimar, Supreme Court of Missouri. This is about basically what's valuable consideration. Facts are Seth Hayden was the common source of title claimed by the plaintiff, the defendant in this quiet title action. On March 6, 1861, Seth Hayden conveyed by warranty deed for $640 the land in question to William Moore, which was not recorded until 1874. Now, in 1863, Seth Hayden, for consideration of natural loan of $5, conveyed the same land to Josephine Hayden, which was recorded in 1968. So basically, Josephine was recorded to Moore. The plaintiff's title is derived from Josephine Hayden, while the defendant's title is derived from William Moore. The lower court found for the defendant, and the plaintiff appealed from the lower court's denial of her motion for a new trial. So I had two issues. One issue on page 1161. Which was, did the deed to Josephine Hayden, because it was reported prior to the deed to William Moore, render the Moore deed invalid and inoperative? And issue 2 was Josephine Hayden, a purchaser of the land in question for good and bad consideration. So Rule 1, courts have repeatedly held that if the subsequent purchaser either had notice of the prior unreported deed, or if he was a purchaser without having paid good and valuable consideration for the land, then he would take nothing by his purchase and deed. The recording statute provides that no such instrument in writing shall be valid except as between the parties thereto, and such as have actual notice thereof until the same be deposited with the court of the record. So Moore did, he paid $640, however, he didn't record until after Josephine. The rule 2, valuable consideration is defined as money or something that is worth money. The consideration does not have to be the full market value of the property. Even nominal consideration is sufficient in the absence of fraud. And there's no evidence of fraud or the Josephine did not pay the $5. There was reversed and demanded for a new trial. Basically, no evidence existed at trial to show that Josephine had any knowledge of the previously executed deed to William Moore. Also, again, as I said before, there was no evidence of fraud or collusion between Seth and Josephine. So, Josephine recorded before Moore,
Even though she got the,
even though she got it back.
right, so he transfers to Moore, but Moore doesn't record.
Yeah.
Right? And then he transfers to Josephine.
She
right,
does record
Who
before
does
he
record.
does.
And then after that, somebody finally tells Moore he should record, so he does, but now he's the second in line. So in Missouri, what's that good for? Who wins?
She does.
She does, because she's first in line. Okay, so that tells you what?
It's a race state.
Probably a race state, but also, did she take with notice? Did she know about the earlier conveyance?
No,
No, she didn't, so looks like she's
she's a.
free and clear.
Yeah.
She pretty much takes. So they make an argument that says, wait a minute though, because the recorded consideration to Josephine was for natural love and affection and $5.
Okay.
What do
They
you think
argued
about
that
that?
wasn't valid consideration.
Does that sound like valuable consideration?
That was the argument, but
That was the argument, and so what did the court say?
I said, yes, it is
Sure,
true.
why not? Again, one of those interesting
fraud.
things.
Yeah.
Yeah, so, and interestingly enough, in real property, when you say, valuable consideration, remember that you can, because of testamentary nature of the properties, right, because you can put them in a will, you don't actually have to have consideration. I mean, again, it's one of those oddities where you can just give someone land. That's okay, quite frankly. But when you do talk about consideration, valuable consideration, because it does play into BFP status and stuff, does it actually have to be the value of the land itself or even close? And the answer is no. It doesn't have to be. It can be something actually fairly nominal, just as long as it's, I guess, recognizable as, I can't even tell you really what it is. I don't know. It's really as long as it's recognizable as some kind of consideration. So it's not market value. A lot of people think it is. It doesn't even have to be close. Just something that indicates that, something of value changed hands, and that's about it. So it could be quite low. But again, unique to, not entirely unique to real property, but one of the more unique aspects of real property is that, in fact, donative intent is fine. You can pass the land without receiving anything in return. Yeah. And that's been that way ever since 1907, right? In Missouri, anyway. Okay. Anyone have anything else they wish to discuss about that case? Yes, no, maybe? Okay, then. I'm good. Again, not a terribly difficult case.
Once you kind of get the concepts down, it's not a difficult area, but it's just a little convoluted to begin with.
Indeed. Okay, well, who's got Gabel versus Dewey's Limited?
Good though. Cool. I'll take that.
Want to tell us about beer distributors and becoming indebted?
So, firstly, facts. McCaffrey was a beer distributor and became indebted to Breweries Limited USA Inc. for beer in a sum exceeding $20,000. Breweries received several over checks, which from McCaffrey prompted him to stop shipping the beers over. So McCaffrey McCaffrey executed a mortgage to the plaintiff juries in exchange for forbearance of any legal action by juries to collect the delinquent in that amount of $20,000. Concurrently, the parties executed a separate agreement stating the debt owed and stated that juries would forbear collection action as long as McCaffrey made timely installment payments under certain promissory notes. The agreement didn't establish a definite extension time for payment of the pre-existing debt, which was evident from jury's attorney's testimony on 1166. Juries recorded the mortgage shortly after its execution. The defendant Gable was a holder of an unrecorded mortgage from McCaffrey that predated the mortgage to juries, and Gable recorded the mortgage after juries had recorded its mortgage. So later juries filed suit to foreclose the mortgage, making Gable a party. Gable filed a cross-claim to foreclose its mortgage. The trial court held that jury's mortgage took priority over the lien of Gable's mortgage and awarded judgment of foreclosure in favor of juries. They stated that the consideration for the note executed was a forbearance from the plaintiff to prosecute any legal action against the defendant, so Gable appealed. The issue in this case was, does an agreement by a mortgagee to forbear enforcement of a mortgager's pre-existing obligation amount to consideration sufficient to support a mortgage's claim for protection as a bona fide purchaser when there's no definite extension of time for payment of the debt was established at the same time the mortgage is executed? So the rule I found was on page 1167 in the bottom, before the last paragraph. If the mortgage be taken to secure pre-existing debt and no new contemporaneous consideration passes either of benefit to the mortgager or detriment to the mortgagee, then the mortgagee does not thereby become a purchaser. So Gabel argues that the agreement to forbear had no definite time, so it amounted to no enforceable right on the part of McCaffrey. It was of no benefit to him or detriment to juries and did not constitute sufficient consideration. However, juries finds that fact immaterial and cites Sweeney v. Bixler. That case surprisingly provides a counter argument that states that a bona fide purchaser exists in accordance with the rule mentioned. They state that new consideration must be present at the time of the execution of the mortgage, otherwise the mortgagee does not become a purchaser. So the court cites several cases where a definite extension of time of the pre-existing debt contemporaneously with the taking of mortgage was given as consideration in order for the creditor and mortgagee to be allowed priority over a prior mortgage. They summed up the situation here that the instant after juries accepted demand and mortgage, it was in a better position than before because not only had it the right instantly to sue, but also reduced a claim for some certain and secured a mortgage on the property of the debtor and an additional covenant to pay attorney's fees and costs if it should bring action thereon. They said that attorney summed up the situation perfectly when he testified it had nothing to lose. So the judgment is reversed with directions to ensure a final decree in accordance with this opinion. So we need to save time frame for payment, basically.
Okay, so, and again, kind of an odd kind of contract case, really, in many ways, but we're dealing with people who put up, collateral in this case against a pre-existing debt. And so the problem is that when you're dealing with mortgages and things of that nature, it's like there's a priority list. And usually it's just first in time, first in line. So when you take out a second mortgage, the second mortgagee knows about the first one. They know that the first one has to be satisfied before they can get paid. So what they're trying to do in this case is the second's trying to invalidate the earlier one, right? So that they can get paid. But the problem being though is, or not the problem being though, is that so they're challenging the earlier document, right? Saying there's no real consideration, right? Because the debt already exists. So all you're doing is you are sustaining a detriment, not really him. He already had nothing to lose because he's already mortgaged it away to you. You know, so again, and when a note of this nature, you can call it any time. That's the whole thing. You know, there's no date on it. And so when he goes ahead and he extends it indefinitely, you see how but that's always the way it was. It's actually not adding anything to it. Does everyone see that? He could call the mortgage at any time. So he says, well, I'll tell you what, we'll sign this contract here. Well, I'll extend the time that I won't foreclose. But there's no definite period. Well, he was already in that period. You see how he had nothing to lose? The guy could have done it at any time anyways. And so if he says, I'll extend it, it could have been for, 10 seconds, 10 minutes, 10 hours? No difference. He was already in that position, so he had nothing to lose. He suffers nothing, right? He's in exactly the guy, the mortgagor is in the exact same situation. The mortgagee has suffered a detriment, but that doesn't really help. So again, it's just a contract case, throwing in with a little bit about, priorities. So the court says, oh, you know what, this is pretty good though, pretty smart. There is really no consideration to this. And so I just find this really odd because again, now we're talking about mortgages and creditors, but wouldn't it have been just better off if you made a donative transfer? I don't know, because you might not even have had that problem at that point. Well, of course there's no, consideration. I gave it to him, which technically you can do, but interesting case, huh? Kind of interesting. Does beer make it interesting? Caught my attention. Okay, I just wondered, All right, I'm good. Good reading. Good reading. Okay, all the readings are good today. Right. Moving on. Osen versus Johnson. Okay.
So this is a United States Court of Appeals in the District of Columbia in 1957. So Osen is the grantor and executed a deed for real property to Johnson in exchange for a promissory note in the amount of $30,000. Johnson promised to record a deed of trust to secure the promissory note, but he didn't ever record a deed of trust. So then he subsequently took two loans from two different lenders and secured those by deeds of trust. Additionally, several of Johnson's creditors secured judgment liens against the property. So lenders got together and filed suit to foreclose on the property in accordance with the deeds of trust that Johnson filed or secured. Osen filed suit requesting rescission of her deed to Johnson, injunction against the foreclosure, and sought other equitable relief. And the trial court concluded that the lenders recorded deeds of trust and the liens of judgment creditors took priority over Osen's unrecorded claim and awarded judgment of foreclosure in favor of the lenders and the creditors. So Osen's appealing to the trial court's decision. The issue I have is whether the existence of a constructive trust would give appellant a superior claim to the interests of the trust holders and Johnson's judgment creditors, should it be found that a constructive trust exists. Yeah, this was a difficult case because there were two separate rules. So the rule I had is a lien based on the recorded security instrument of a bona fide purchaser of an interest in real property takes priority over a prior equitable interest, but the lien of a judgment creditor takes priority only if the prior equitable interest was capable of being recorded and then wasn't recorded. So the trial court found that Osen was induced fraudulently to convey title to Johnson by his promise that he would record a deed of trust, but they didn't consider whether fraud would entitle OSIN to a constructive trust over the property essentially. I had to look up, I didn't even know what a constructive trust is, but now I do.
I have to talk to those tort guys. You know what that is?
Maybe it's more once you get to remedies and tort.
True.
Yeah, because it's a remedy, right? I mean,
Oh, yeah, we talk about it extensively.
it's an equitable remedy, so it gets put into a trust when there's, I think specifically when there's fraud or
Mhm.
bad faith involved, right?
Yeah.
Okay.
And title is involved usually.
Yeah,
So in other words, they took your money and they spent it, and for instance, they gave you $30,000, you were defrauded of $30,000 and they bought a house with it. A constructive trust says, as a matter of law, you were the trustee for that money, so therefore hand over the title of the house to the person whose $30,000 it was, because it's only fair. That's what a constructive trust is. But just so you know, it usually involves title, because title can be handed over. So otherwise, it's probably something else.
all right. The court says a constructive trust can be imposed upon property wrongfully retained by one that would be unjustly enriched if they were allowed to retain the property. A constructive trust establishes an equitable interest in the property, and it arises as a matter of law. They say even if OSIN is entitled to a constructive trust, the recorded interest of the lenders takes priority, and the evidence demonstrates that the lenders were entitled to protection as a bona fide purchaser under the Recording Act. They also say it's been a longstanding doctrine to hold the interest of bona fide purchaser superior to a pre-existing equitable interest in real property. They say, however, though, the lien of a judgment creditor generally stands inferior to any pre-existing equitable interest for the reason that creditors don't typically rely on an examination of a debtor's real property interest as grounds for extending the credit that they give. The judgment creditors assert that the recording statute should modify the general rule by specifically including creditors among the parties entitled to preference over all prior interest. But the recording statute only gives that priority to the creditors with respect to existing interests that are required to be recorded and capable of being recorded. And they say an equitable interest can't be capable of being recorded. So they hold that if the evidence supports a constructive trust in favor of OSIN and demonstrates that she hasn't waived her rights, then the constructive trust interest will take priority over the claims of the judgment creditors. But any creditor that can demonstrate that they had detrimental reliance on extending their credit, essentially, they'll be treated as a bona fide purchaser unless the creditor had actual or constructive notice of Johnson's fraud against OSIN. So they affirm as to the lender's interest secured by the deeds of trust, but they reverse as to the judgment creditors and remand it. So it's kind of like affirmed in part and reversed in part.
So yeah, so it's a look. It's funny because it's kind of it's very good, by the way. This is not an easy case. The actual issue in the case is fairly straightforward when you finally get to it. It takes a long time. The thing is though we don't really know how this case. I don't know how this case actually turned out because again, notice they send it back down, right? So we don't know what the actual facts turned out, and I haven't found anything on this case, at least that I can remember today. You can do some fun. But anyways, the question becomes, it's kind of a curiosity case though, because it's inequity. And what we have is we have a situation where it looks like we have a defrauded, a defrauded investor of some sort or lendee. And the thing is she kind of gets caught in the middle here. Because what happens is if you look at the statutes, that it looks like the situation is you have to record, right? Now, the problem is that this court is looking at the trial court and saying, but the trial court should have considered that she had a constructive trust. She was defrauded. Now, if she has a constructive trust, then she has a right to this property, right? So what they're doing is first they're saying, so we have to send it back down so that the court can figure out whether she was entitled to a constructive trust or not. Obviously, they're kind of saying she is. Now, why that becomes important for our purposes today is because then the fact that they actually recorded, right, that the other lender who got this judgment lien actually records it is of no particular value. Why?
Because it's an equitable remedy, right? And
And
you can't record it.
you can't record it. There's, what are you gonna record? Again, there's no paper, you know, because the court didn't, you know, I mean, if she had a piece of paper that said, hey, look, the court said I have constructive trust, so be it, but the court never recorded it. And so technically speaking, also when you have a constructive trust, there's no paper. You know, there's not a constructive trust deed. It's not that kind of thing. It's an equitable remedy. So there's no real paper to put on file. Although I do want to remind you guys, in case you ever wonder, that you can literally file anything. You could file a phone book if you felt like it. I don't know why you would. But technically you slap a cover page on it and pay, and you're supposed to be able to put anything on file. So again, if there's ever a document that you think your client or you want on file that you think influences the property, technically you can do that. I mean, I think as long as you have a good reason, you know, but that's about it really. There's not too many rules about it. It does have to have some effect on the property, otherwise, you know, touching concern type stuff, otherwise you're in trouble. But the thing is also very interesting though, because, so let's say that, but how this case and why it gets a little tricky is because the creditor isn't shut out yet though, because one of the things becomes the question is, are they a BFP? They look at that as well. And they say that is possible. I mean, if they didn't know about the fraud, why would they have any reason to believe that there's a constructive trust, right? So they're sending it down for that too. And that's actually where the case stops. So it's possible depending on, you know, how you read the statute. But I think what this case, at least in my opinion, is interesting is because it takes a couple of the concepts we saw before and it kind of puts it into this sort of creditor fraud, constructive trust thing. Because, you know, again, you have like adverse possession. There's no document until you get a quiet title. But it doesn't mean you don't own the land. You do. Same thing here. If she has a constructive trust, she owns the property. It's just that she has no particular piece of paper to actually put on file. And in this case, she can't anyways because the district court didn't even do it. But again, according to the statute, it is possible that this lender who has a judgment lien, which is usually subservient to these things, could still win out because the statute says so if they in fact are found to be BFP. Right. Okay. So good reading of the case though, not bad at all.
Thanks. Now, had she recorded it, because the court talks a lot about how she didn't record it and she was negligent because she didn't record it. Had she recorded it and she's just a defrauded grantor that recorded it, right? Would she have,
right?
I guess priority then over a BFP or the other creditors?
Possible, because then the other creditors would know that she was defrauded. And so can you be an innocent purchaser when you know there's an outstanding claim? No, due to from them. So they wouldn't be. Notice how it's funny too that you mentioned that, because notice how, and all courts don't do this, but notice how some of them say just bona fide purchaser, and some of them say innocent purchaser. Like you really have to not know about these things. And so in this case, they use innocent. You notice that? So they're saying we're not quite sure that they're innocent in this case. We think they might have actually known that. So, but yeah. Cool. So again, kind of a complex case, but everything we've kind of seen this though before, so that's why I kind of like this case. Is that you sort of put the pieces together, and then you can kind of see though, you know, when you have multiple creditors and all this stuff's going on, and you've got to really, if you ever do this type of law, I personally just do just enough of it to get by for my purposes. But there, really what you're doing is you're, particularly like bankruptcy law, it's like you're putting the creditors, they have different categories for different creditors and things of that nature. And, it really makes a big difference whether you're a creditor or a non-creditor, a donee or a buyer for value, fill in the blanks.
Secured creditor, unsecured creditor.
Yeah, unsecured, secured, this whole thing, they come in different levels. Yeah. And so you're always figuring out what level you're at because it's gonna run out somewhere, So it actually is really important, makes a big difference. And if you want to see some cases how it works, bankruptcy would be a really good place to look because you can really see the effect of how creditors fight to get in certain positions and stuff like that. And yeah, being secured and non-secured is really kind of a big deal because if there's an item to get that, then certainly you want to get it back and sell that for the value of it. So that's why secured go first, by the way.
Yeah.
It's just so they can, if the item still exists, they can go get it. Usually it does, but that's actually why. So because the unsecured claim is just for money, so it's either money left or there's not. So it actually makes a lot of sense.
Yeah.
Anyways, but in this case, kind of follows that sort of interesting logic we use when it comes to debts. So, see, the bank doesn't always win. There's that 0.2% time. Sorry. Banks are not my favorites right now, so they're pretty crazy. Anyways. Okay, how about Weinberg versus Moore? What's this? This is in California.
Okay, so in this case, Weinberg is suing for quiet title on 880 acres of timberland in Humboldt County, California. Weinberg alleges that he purchased the property from Barker in May of 1948 for $6,000, but he failed to record the deed until May of 1951. Before Weinberg's recording of the deed, Barker sold the timber on the land to construction engineers and that deed was recorded. And then in 1951, before Weinberg recorded his deed, Barker sold the property again to Natural Resources Inc. and they recorded the deed before Weinberg. So here, procedurally, Weinberg filed for quiet title against the defendants, and the issue is whether or not Weinberg's possession was sufficient to impart notice to Construction Engineers Inc. and Natural Resources Inc. The rule I have is on 1175. In the absence of actual inquiry, a person is still chargeable with the notice imparted by possession. Such notice is akin to, if not equivalent to, constructive notice. So here the court discusses the view of the premises, which is an actual visit to the property. The possession must be open, notorious, exclusive, and visible, and not consistent with the record title. The court said that in viewing all the evidence, the deeds from Barker to Construction Engineers and Natural Resources was not in good faith. Here, Weinberg paid taxes, he had a dwelling on the property, a woven wire fence, and he visited recreationally, his friends visited. He had no trespass signs, it had his name on the signs, and there was also the presence of personal property inside the home and several no trespassing signs. So that showed Weinberg staking a claim in the property against others. And the court said that that was sufficient where an inquiry would have revealed Weinberg's interest in the land, and therefore they didn't get to close their eyes to everything but the record title. So they ruled in favor of Weinberg.
This is kind of a, we don't get to bury our head in the sand case, right?
Just out of curiosity, and that was fine, by the way. What do you think, though? I'm just going to ask a question, just out of curiosity, because I've always, and again, I can't say this for a fact from this case, but I think it was what actually made Weinberg the winner. What fact do you think I think was actually the one that the court said, you didn't know about this claim, huh? Did you check what did Weinberg do that the other party did not?
Pay taxes. Pay taxes?
He paid taxes. What do you think about that?
Mm-hmm.
Plus those signs that he had on there that says stay out too, has something to do with it, but you know, Weinberg property sale, probably everything that was there, the houses and everything. But it's interesting because they make a pretty big point on that in 1177 at that Weinberg paid the taxes upon the property and they give you the whole thing. But notice how they put that first. Because that's something, you know, if you looked at it and you said, well, who's this guy? You know, that kind of thing. You might want to check that. I think I would look at the tax rolls and make sure at that point if I do. So what's the rule? Strangely enough, it's a very common sense, not the rule of the case, but what's the rule when buying and selling real property? What do you never, ever do, which people do all the time, by the way, if you want to stay out of trouble. Don't buy property sight unseen.
I told you guys you're buying a lawsuit.
It's crazy. It's insane. I can't believe how many people just send their money halfway across the United States and they show up and plan, oh, there's a trailer on my property. How did that get there? Go ahead. Anything else? Just saying, don't ever buy property sight unseen. Don't do it. People get an enormous amount of trouble doing that. It's amazing.
So we get one final case that is our chain of title case. That's gonna be Sabo versus Horvath.
And it's in Alaska.
And then that's all you have to think about. And then next week is spring break, right? Am I wrong about that? Did I just tease it and wrong?
Oh, yeah.
Okay, right.
We still have some problems.
I mean, you don't have any more real property. I know that hurts you. Right?
I just showed it to you.
That's what I thought. That's what I thought. Thank you.
And before whoever does this case, a patent is just a grant of land from the government. It's not a patent. We talked about that. I've had students who have to read this case and they say, what's a patent got to do with it? There's no inventions in here. And then I kill them. You know, that's just like instant.
Come on.
You know,
Deny.
they're never gonna find my burial grounds. Never. Who wants to do this case?
I will do this. Okay, Alaska case.
Do you have any relatives that would look for you? I'm just curious.
They'll look for my ATM card. That's about it.
Just go.
Man,
Come out of the woodwork.
Oh, that's for sure.
They've already told me that, so.
that's reassuring.
I know, it
Be
is.
leaving everything to a friend.
Yeah.
I can see my family. Where's his will?
Okay,
dear.
so this is an appeal, because Grover C. Lowry conveyed the same piece of, land twice. It was a 5-acre piece of land. So Grover Lowry occupied land in the Chitna Recording District on October 10th, 1964 for purposes of obtaining federal patent.
You know, the only thing I think about this case is, oh, only twice?
Only 20.
Yes, Alaska.
So then, he filed a location notice on February 24th, 1965, and made his application to purchase of the, on June 6, 1967, with the Bureau of Land Management. In March 7th, 1968, the BLM filed a report recommending the patent issue to Lowry. So on October 7th, 1969, a request for survey was made to the U.S. government. In January 1970, Lowry issued a document entitled Quit Claim Deed to the Horvaths. So the Horvaths recorded the deed on January 5th, 1970 in the Chitna Recording District. So Horvath testified that he knew patent and title were still in the U.S. government, but he did not re-record his interest after patent had passed to Lowry. So following the sale to the Horvaths, there was further action taken by Lowry and the BLM pertaining to the application for patent and issuance of the patent on August 10th, 1973. Then almost immediately after the patent was issued, Lowry advertised the land for sale in a newspaper. So then he executed a second quitclaim to the Savos on October 15th, 1973. So the Savos recorded this document on December 13th, 1973. So then I had down so the transfer of the Horvitz predated patent and title, and thus the Horvitz interest in the land was recorded outside the chain of title. So that's when the Horvitz brought suit to quiet title, and then the Savos counterclaimed to quiet their title. So I found two issues. I had here that whether Lowry had interest to convey at the time of his transfer to the Horvitz. And the second issue is whether the Savos who received their interest by means of quitclaim deed can ever be innocent purchasers within the Alaskan statute. I think that's what it is, the AAAS statute. So as a rule I have is if a grantor, Lowry, transfers prior to obtaining title and the grantee, Horvat, records prior to title passing, a second grantee who diligently examines all conveyances under the grantor's name from the date that the grantor had secured title would not discover the prior conveyance. So here they have that. So the Savos are asserting that their interest supersedes the Horvats under the Alaskan statutory recording system. So it says that a quitclaim only transfers the interest of the grantor.
Mm-hmm.
So the court holds that a quitclaim grantee is not precluded from attaining the status of an innocent purchaser. All right. So they said that most jurisdictions adopted this grantor-grantee rule, and a wild deed does not serve as constructive notice to a subsequent purchaser who duly records, and Alaska utilizes this grantor-grantee index. The court also mentioned that if the Savos had searched under the grantor and grantee names, but limited their search to the chain of title, they would have never discovered the pre-patent transfer to the Horvats. So they hold that the Horvats deed recorded outside the chain of the title does not give constructive notice to the Savos and is not duly recorded under the Alaskan Recording Act. So since the Savos interest is a first duly recorded interest and was recorded without actual or constructive knowledge of the prior deed, so the court holds that the Savos interest prevails.
So wild deed, right?
Yeah.
Now we all get the example of the wild deed.
But on this one, it says that part, when you made the chart, there was no, no knowledge of it.
Mm-hmm.
So,
How could you? There's basically a hole in the chain of title. There's a missing link. There's a missing piece.
okay.
That's what I was trying to say. It's like links of a chain. At some point, if there's a missing piece, it all just starts flying around. You can't know what came before. It's just not there.
Just so you know too, in this case, just reading this case, but I'll just tell you. And also, it's very interesting, and it's an odd case because we don't hear about very many of these. So in Alaska, they get quite a few. So this was actually kind of a big deal. Believe it or not. The reason why is, have you asked yourself why it is that this deed was outside the chain of title in Alaska? Where was it held? They said they had a patent, right? Is that not correct? So where was the knowledge of the patent being held? Why could it not appear in a grantor or grantee deed? Anyone think about that? where it actually is. Well, all patents until they actually transfer are owned by who? US government. You think there's a part in the US, in the Alaska grantor grantee index that says US government? It would be like this huge massive thing. And so the patent, until it actually passes the time period, a homestead is held in the name of the United States government. And so even though they did have a reasonable, claim to the land, it could not appear in the actual Alaska grantor grantee because they didn't, the Oregas actually did not own the US government until the time. Just so you know. So it's that's why they're kind of waxing and waning philosophically, because a lot of people get property that way in Alaska, and you want to go up and homestead, you're going to pay. So it took them all, a little thinking about this one. But in the long run, they said, but on the other hand, index is the index. So you get down here, it'd be like homesteads. But up there, they still do it all the time. So it's actually kind of a deal. I've always wondered what the federal government has to say about that too. Who the hell do you think you are, Alaska? Taking one of our patents and validating it. How do you like that? Alright, anything else?
All right, at least from us, happy spring break.
It's in the.
Six that is cute. Oh my god, it's really
Nutritious punch.
Actually, now,
Yeah.
anybody else?
Oh wow. Kids, I'm gonna kick my